May I please also? I like to mention one RSA matter for hearing on 4th or 9th. It was actually last posted on 19th of May. Of course, on that day it did not reach RSA matter. Actually, it's a tenancy matter. Tenant, on the pretext of pendency of this appeal, Your Honor, he has not paid his rent, not a single penny, since the days of 2006. Is it? Yes, Lord. Yes, Lord. It was last posted on May, 19th of May, of course. Yes, Lord.
No, sir, I paid for listening of the urgent CRK today, Lord. Here is the urgency, Lord. Yes. No, are not CRP I will. Yes. My Lord, similar prayer, my Lord. CRP I urgently, my Lord. Stay has been granted without, can this matter be taken up today? March on.
May I please, Lord? My Lord, with the consent of the other side, I beg to mention item number 14, my Lord. Kindly pass over for the day, my Lord. Okay. 14, 1-4.
May I please, my Lord, I beg to mention item number 12, my Lord. My Lord, I am for the petition, my Lord. I have taken consent from the other side, my Lord.
I'm waiting for a respondent.
My Lord, my senior is out of his session, so I pray that this matter be adjourned, my Lord. And my Lord, if possible, can it be on 10th of June, my Lord?
Yes, sure.
Obliged.
May it please Your Honor, I would like to mention one matter appeal, if possible, on 11th of June, Your Lordship. Okay.
With regard to item number 35, I am having the consent of the other side. I would like to mention this item. I'm for the respondent number 1.
Consent of the other side, counsel for the respondent number 1 place for adjournment, prayer is allowed. This after?
4 weeks.
Okay, this
The
after
date will be
4 weeks. Will be after vacation. You make a prayer then for listing because we can't accommodate right now.
Similar period, Lordship. Regarding item number 13, Lordship. Which is conducting senior counsel Mr. A.C. Sama today's personal inquiry.
13.
13. 1-3, Lordship. Consent taken of the respondent.
After the respondents, my lord.
Okay. You, but this is come by orders. Because wait, this has come by orders.
1-3,
my lord.
Admission matter.
1-3, somebody made a mention and therefore it has come. You can't take an adjournment like that.
You have other respondents. We made the mentioning.
So then can't.
So conduct the senior counsel today out like
But
that.
could you see it's come by listing.
Respondents are Lordship mentioned, Lordship.
This one 5/6/2026 as paid for by one counsel for the petitioner.
Well, it's a date make any difference.
Lordship, kindly date me on 15, either 16, 17, any date, Lordship.
Let's 2018 execution matter is stayed again.
15, 16, 17, any date, Lordship.
What is the difficulty on this?
in your, not,
Will not be available.
okay,
Okay, make it 15 then.
that's it.
Be published.
Okay.
No,
But the
adjournment
earlier
will be
it is-
granted on the exit of this thing as execution cases are pending, execution proceeding have been stayed.
But the interim notice.
Interim order passed submit and the telling processing.
Sorry, my lord, in item number 14, my lord, interim is there, my lord.
14,
Yes, my, 14, 1/4, my lord.
okay, 14, interim extended. Okay,
Please, Your
Most
Lordship.
of it.
I'd like to mention for listing of a CRP
I think give it to the court master.
in your withdrawal.
This is for the 6th time I am telling, please give it to the court master.
May I please, Your Lordship, I would like to mention item 5. Adjourn this matter for the.
5,
Yes, my lord.
okay. This one, 8/6/2026, as paid for by law and counsel to the petitioner. Okay. Yes,
Obliged.
Lordship, I beg to mention item number 10. Mr. P.P. Das, the engaged counsel, has some difficulty today. So, will the matter be adjourned?
you're taking consent of the other side.
Yes, Your Lordship.
This one, 8/6/2026, as paid for by law and counsel. to
After
the-
vacation, Your Lordship.
Why? This is still operating here,
There is no interim order.
no interim order.
No.
Okay. This part of the question.
I'm obliged.
There you go.
Yes,
I will do up to 29 not, 29 not. After 2 weeks. Not. I'm going to put this in order.
here made by law and counsel to the petitioner, list after 2 weeks. Okay,
Obliged.
May I please, Your Lordship, I beg to mention item number 22. I have taken consent from the other side and I'm on behalf of NN Jha.
consent of the other side, the law and counsel for the petitioner pays for adjournment, where is allowed. List after,
On behalf of Mr. NN Jha.
list after how many days?
So, as per your convenience, Your Lordship.
This one, 17/6/2026.
17. Much obliged.
Lordship, may I please? I would like to mention item number 11. Actually, we are unable to file additional affidavit due to shortage of one document. So Lordship may kindly give 2 weeks time, and we have taken the consent of other sides also.
Your father,
I am for the petitioner and on behalf of Mr. M. Kalita.
the consent of the other side, the law and counsel of the petitioner pays for adjournment, where is allowed. List after,
2 weeks.
okay.
Much obliged.
Motion, item 1 with 2.
My lord, in item 1, we file an amendment petition to amend the cost title. My lord, the IA was wrongly in cost title mentioned as an IA under 227, which ought to have been, my lord, IA under section 115. So, my lord, that cost title may be allowed to amend, my lord. Okay.
Where you have made a mistake,
My lord.
Where is the mistake? In which application there is
My
a
lord,
mistake?
post title of the CRP 35 2026, my lord, in post title, my lord.
Okay, you want this to be,
First page. It was mentioned as an application under Article 227 of the
you
Constitution.
want it to be only 115?
115, my lord. 115 read with 151 CPC maybe, my lord. But 115 is the main, my lord.
Your name?
My,
Acha. Oh, I'm sorry.
my, I am for
The application is by you.
application for
Please by
by
you.
me,
Okay,
my
okay.
me.
So here, Sigdar Lavit.
Where for the petitioner, my lord, my name is not shown in the
Okay,
post title, my lord.
When it comes to the petitioner submits that the application for amendment, this is in 1743, has been filed to strike out the provision of Article 227 in the cause title of CRP 35 of 2026,
Yes, sir.
so that this would be so that the said CRP would be an application under section 115 read with section 151 CPC. So this next paragraph, it's a BJ Mukherjee, learned counsel for the respondent. Does not object to the prayer. Post of prayer is allowed. The application stands disposed of. And okay,
My lord, it may come up in the next 5 days, my lord. There is an interim order in item 2, my lord.
so we'll take it up.
My lord,
We'll take it up because the office will do the necessary correction.
my lord.
Yes.
My lord, in item 2, there is some interim protection, my lord. And that
What
may
is it?
continue, my lord.
What is the
lord,
the CRP for?
My lord, against the, my lord, execution proceeding.
What is the ground of challenging the execution proceeding?
My lord, in that case, my lord, during the pendency of this CRP 3526, my lord, they have proceeded for execution. And the
Yes.
writ of possession was issued, and we prayed for grant of stay by showing the filing of the CRP number 3526. At that time, because of the delay, it was not numbered, madam. And that petition was rejected. Against that, we have paid for stay of the execution, and that was not considered, and it was rejected. Therefore,
In the execution proceedings, who are you?
my lord, we are for the defendant, judgment debtor, and the other side is, my lord, they have got the decree. They are going to execute the
Yes, what is,
judgment,
why it should not be executed?
my lord. Ground is that, my lord, they are claiming that we have sold the land, and our challenge is that we never sold the land.
But that would be a question of appeal. How can the executing
My
court
lord,
decide that?
appeal is since the proceeding, my lord, was instituted under section 6 of the, there is a bar of filing an appeal under section 6 of the specific
It's
legal
under
act.
section 6.
Therefore, our appeal before the court, lower court, it was returned, madam. And ultimately, we have no option to file the revision.
Okay. Now, where is your what do you call? Where is the evidence tendered by you in your case, and where is the written statement?
My lord, in here, we have produced some documents in the CRP
Where is your
35.
Where is your written statement? 35.
Written statement, my lord, 21. Yes, 21.
No, 35 is not the written
Page
statement.
number 21. My lord, in
20?
21, annexed 2, in CRP 35 of 26. Yes, my lord. Both the matter may come up from Friday,
No,
my lord.
no, this execution proceeding is being stayed, that's why we.
My lord, there is already, my lord, on that point, there was matters of hard and there is some interim, my lord, in item 1.
We understand
That may
that.
continue only till next date, my lord.
No, that's why we are trying to understand. You see, please come to page 23. Come to page 23, your written statement.
My lord.
Now. you
Yes,
have
my
taken
lord, we
a-
have challenged the deed in question
You
as a
have-
forged, fake and fictitious documents.
Now, please come to your evidence of PW, of DW, whether it is there or not.
Lord, evidence. My lord, evidence, evidence of, PW1, annexer 5, page 59.
Yes, so you see, under section 6, what is required is that somebody must have been dispossessed within 6 months. Question of title is not to be gone into. If you have any dispute with regard to title, then you can file a separate suit. Because please come to this page 60, which is the cross-examination. Para 3, the witness says, I have issued to the government land, government did not issue allotment to me, I purchased the land from the defendant. And then last paragraph, it says, so-and-so in respect of different land, they cannot identify the land involved in their case. I filed this case in connection with so-and-so. And then next page, you find that it is the position. It is not a fact that the position was handed over to land in presence of public. It's a question of position and
My lord,
disposition.
it is their admission, that,
But if you dispute the
I
fact-
was in possession.
But if it is, if that is disputed, you will have to file a civil suit and get your, because the court comes to a finding that she has been dispossessed 6 months prior to the institution of suit.
Lordship, with all observation, may close the matter, to file a separate suit, my lord.
We will take it up, you be prepared, we'll take it up day after tomorrow.
My lord, my lord, my lord. My lord,
In this
interim in,
CRT 35, in view of the order passed today in so and so, the registrar shall strike out the provision of Article 227 from the cost title of this revision, and so accordingly, this revision shall be treated as one under Article under Section 115, read with Section 151 CPC. So as both sides are represented, court is trying to issue notice returnable forthwith without requiring any steps to be taken. List in the admission column on 3/6/2026.
my lord,
Interim order is passed in which
my lord, in, CRP 209/2024 by order dated 6/6/24.
209.
26, my lord, 26/6/24.
In 209. Mr. Sridhar, counsel for the applicant and the Mukherjee for the respondent. This stays in IA 209.
Yes, my lord, in CRP IO 209/24. Order dated 26/6/24.
And IA 209, we say that interim order passed from 26/6/2024, stand extended till 3/6/2026. List accordingly. On 3/6/2026.
Deep lovely.
Item 3.
Excuse your worship. Worship, on last occasion, there was an inadvertent error in page number 8, para 16 of the petition. The lordship was pleased to allow the petitioner to correct it by hand. The petitioner has
Para?
done correction for para number 16. Second line.
Okay. But is it higher planning council for the petitioner?
Lordship, there was a prayer of interim relief, lordship.
By calling this application under section 24 CRPC, SCC of the CPC, the petitioner, who is the estranged wife of the respondent, is seeking transfer of matrimonial proceedings, comma, being page number 1, being matrimonial suit within bracket divorce number 59 of 2025. Filed under section 13 within bracket 1 within bracket small I dash A bracket close, again bracket I dash B bracket close, of the Hindu Marriage Act before the Court of Learned District Judge, Nagaon. The Court of Learned District Judge, Gauhati. Next, the Learned Counsel for the petitioner submitted that the petitioner is an unemployed lady and is completely dependent on her parents, and it is difficult to travel to Nagaon to contest the proceedings. Next, issue notice written about on Stonesville. Petitioner shall take steps within 2 days for service of notice on the respondent by speed post proceeding. Next, the petitioner is being counsel for the petitioner is at liberty to collect the postal receipt number and submit postal track report prior to the music of listing. Next, in the next returnable date, proceedings of matrimonial suit within the divorce number so and so, pending before so and so shall be then state. Next, how, comma, this. Petitioner should cause production of a certified copy of the order before the said Learned Court to be the order to the notice of the said. You just before the said Learned Court to make it effective. Produce a certified copy before the court. And take steps within 2 days. Item number 4.
Hello, the husband filed the divorce suit at Silchar Mala, and petitioner wife is the resident of Kamrup Mala, Gauhati. So,
Mr. N.K. Kanital and counsel to the petitioner, page 1, transfer of FC Civil so and so from Principal Judge Civil Court Kachar, Silchar to Family Court, Principal Judge Family Court, Kamrup Metro, Gauhati. Petitioner is citizen, sorry, the resident of Gauhati, and you have a child also.
yes, madam, 6 years old, madam.
Also taking care of the minor child of the parties. It is difficult for her to travel to Silchar to contest the proceedings. Returnable date, return date after 5 weeks.
Okay, but state the procedure. Obliged.
But you have to produce certificate copy though.
Yes.
Item
Item
6. Item 6.
Yes. My lord, my lord, we have challenged the my lord improved order that your lordship will find at page 88. Page 88, my lord, the improved order, my lord, and authority part lordship will find.
You have the plaintiff or the defendant.
My lord, plenty. Page 92, lordship will find the authority part, my lord, paragraph 30 onwards.
Where is your application for interim order?
Yes.
Injunction application, where is that?
Yes. My lord. Page 71, my lord.
71. You have to withdraw this and come in appropriate jurisdiction.
My lord.
This is the original order passed by Civil Judge Senior Division.
My lord.
Against that, CRP would not lie.
Now, my lord, since section 6 is, my lord, cleared bar under the Specific Relief Act, my lord.
Section 6.
Yes.
This is a suit for suit under Section 6.
A Specific Performance Act, my lord. Plain lordship will find at page 42. 42. 43 is the, my lord, subject matter. Page 43, my lord.
Then the order is absolutely correct. You have filed a suit under Section 6 of the Specific Relief Act.
My lord.
No. This can't be a suit under Section 6.
Yes.
Number one, there is no, in the cost title does not show it is Section 6.
Yes, that is not.
And the prayer can't be a suit under Section 6. If it is so, then we'll reject your claim right now. It will be what you call very a difficult order for the court to pass, but still
Now, my lord,
we'll put you a question why Order 7 Rule 11A would not be applied here.
now, initially, my lord, lordship kindly see, initially, page 84, lordship kindly see for a moment, my lord.
No, you see, come to page 42 first. You say this is a suit under Section 6.
Yes.
Where do you find in this claim that this is a suit under Section 6?
That is not specifically mentioned, my lord.
Can you file a suit under Section 6 without specifically mentioning it?
Page 43, lordship will find.
I'll come by one. I am in no hurry. You have time till 4:30 to ask you questions. There is no hurry at all. Now, please tell me, according to you, what would be the prayer under Section 6? And how and why Section 6 applies? In which cases Section 6 applies?
My lord, why
I'll give you the book. If
Yes.
you don't have the book, give a specific relief act. The book. You have it?
Yes, sir.
Okay.
Now,
What is the
section,
condition precedent to file a suit under section 6?
yes. Well, section 6 says, my lord, sued by a person disposes of immovable property. If any person is dispossessed with his consent of the immovable property, otherwise, then in due course of law, he or he may person claiming through him by suit recover possession thereof, notwithstanding any other title that may be set up in which suit. Now, 3, their lordship will find, no appeal shall lie from any order or decree
Now,
passed in any.
page 51, your prayer.
My lord.
Please read.
Yes. Page 81, my lord. Yeah,
51 is your prayer.
81.
I don't know. In my copy, it is 51. 51.
It's here. Oh, that is, I am. It is therefore prayed that your honor would be graciously pleased to degree of a specific performance of the contract passed in favor of the plaintiff against the
Degree of
defaulted.
specific performance of contract.
Yes. On
You
the
just
basis,
now read section 6. Is it covered? No. Now come to prayer 2.
degree be passed directing the defendant to execute the registered sale deed
Still deed.
in
Yes.
favor of the plaintiff.
Have
in
you
the
seen your, that, does it match with your section 6 you have read?
That is,
No. Then come to prayer 3.
in the event of failure to execute the registered sale deed in favor of the plaintiff by the defendant, this honorable court may be pleased to execute the registered sale deed in favor of the plaintiff, retaining the
Yes.
balance amount of considered
So again,
70,000.
is it covered in section 6?
Apparently, no.
No, I don't know, because you say you are the master of the brief. I'm just asking you. You treat me as a person ignorant of facts and law.
That is, my lord, my understanding. That may not be correct.
Are you permitted to make an incorrect submission before the court? Can you do so? And if you think that that is a license you are getting, then we send you to the bar council. Why should we not send you? When you know that you are wrong, and then you make the wrong argument before the court of law. Why we should not send you to the bar council? Then we are sending you there. This is not appropriate. This is not a common place where you can just come in, just like a park, treat the court like a park, come in, go to left, go to right, whatever, and come back. We can't allow you to do that. If you think this is a case under section 6, then better go there. There will be, in bar council, they will teach you law. Whatever was not taught at the college level will be taught there. Then you will understand. It's not very easy for us to digest that submission. That is my argument. You are not permitted to do that. Waste the time of the court. Not only will dismiss this application, but will send you to the bar council. You can't tolerate that. There's something which hits the majesty of the court. You are almost short of slapping the court that this is what I am doing. Do whatever you want. We will not permit you to do that. We'll compel you to argue what the law permits.
That's true, my lord. I'm extremely sorry for that, my lord. But
no, that takes away the majesty of the administration of justice. Anybody can come and tell the court anything.
definitely,
No,
definitely.
we are dismissing this, and we are also sending you to the bar council.
Now, my lord, only
We are dismissing it. If it is section 6, your case is being dismissed in limine.
my lord, most respectfully, my lord, I beg to withdraw this submission, my lord. You should
We will not permit you. We put you that question and you insisted that this is my submission. We will not tolerate that. heard Mr. M. E. Mandal and the counsel for the petitioner. He has submitted that the proceedings of TS number 5 of 2025, which was instituted before the learned civil judge, Senior Division, Barpeta, is a suit under section 6 of the Specific Relief Act. Full stop. At this juncture, the court asked the learned counsel for the petitioner to read out the provisions of section 6 of the Specific Relief Act. Full stop. Having read the said act, the court posed a query as to whether any of the prayer made in the plaint is covered by the provisions of section 6 of the Specific Relief Act. Full stop. For a better understanding of the prayer made in the plaint, the prayer made in the plaint is extracted below, page 51, page 52. Full stop. Next paragraph. On a query of the court, the learned counsel for the petitioner submits that he may be incorrect in his making his statement, but that is his also submission. Next paragraph. It is at this stage that the court takes an offense of the nature of submission made by the learned counsel for the petitioner. Stop. The learned counsel for the petitioner cannot be permitted to make any submission which he likes and then make a statement that that is his understanding of law. Full stop. The nature of prayer made in this suit has no bearing with the provisions of section 6 of the Specific Relief Act. Full stop. Moreover, the prayer made in the plaint, none of the statement made in the plaint, including the cause title, the nomenclature of the suit is stated to be one filed under section 6 of the Specific Relief Act. Full stop. Therefore, the only impression that the court can gather from the nature of submissions made by the learned counsel for the petitioner is that not only is ignorant of the provisions of law, but against an order passed, against the impugn order that was impugn order dated 25/7/2025, which was passed by the learned civil judge within bracket Senior Division bracket code Barpeta in BCA case number 171 of 2025, arising out of TS number 5 of 2025, which is an order of injunction, ordering an appeal would lie against any order that is passed under Order 39, Rule 1 and 2 of the CPC. Full stop. Thus, in order to avoid filing of an appeal, by way of a revision under section Article 227 of the Constitution of India, read with section 151 of the CPC, an order of injunction has been assailed, and to sustain his submissions, the learned counsel for the petitioner refers to the suit as a suit under section 6 of the Specific Relief Act. Next, therefore, as we find that the learned counsel for the petitioner has made a false statement, knowing it to be false, not only it deserves dismissal of this division in limine, as the order of injunction passed under Order 39, Rule 1 and 2 cannot be assailed under Article 27 of the Constitution of India. Nonetheless, as the learned counsel for the petitioner has wasted the time of the court and has made submissions by referring to section 6 of the Specific Relief Act, there is a definite reason for the court to believe that the learned counsel for the petitioner was attempting to mislead the court. Accordingly, the matters, the said conduct of the learned counsel for the petitioner is referred to the Bar Council of Assam, Nagaland, etc. Next, this revision stands dismissed. Next, get a copy of this order to the Bar Council of India, Bar Council of Assam, Nagaland, etc. to take a call in the matter. Next, the registry shall send a copy of the order along with a copy of the this revision application for the consideration of the said authority. I just in terms of this.
But may I pray one thing, what has been submitted by me before his lordship?
You file an IA and withdraw it. If you want to withdraw it, we can withhold the transmission of the order for a day. You file it by tomorrow, get it, and bring it.
That is I am submitting, but I may
Do it. If you file an IA, we'll consider, but the order once passed is passed.
I may be allowed to do this revision petition.
We'll do it when you file an IA, because once an order is passed, we are not withdrawing the order of the court, passed in open court.
Developed.
Yes, item 7.
Item 7.
We'll take it up in second call. Nobody is there. Item 8.
Maybe lordship, pertaining to this case, some documents I have not received lordship. Last time I also taken some argument lordship. So may I pay some time because some document was signed lordship. Page 18 is my petition, sir. We are sending two, but not yet signed. lordship.
Just a moment. You see, you know, no difficulty in adjourning.
Yes,
But come to page 27.
yes, lordship.
The earlier lawyer withdraw because there was no
Yes.
communication. Even you say that there is no communication.
Yes, sir.
On the period made by the counsel for the petitioner, list after.
Next week, lordship, we can documents,
Yes,
we have page 19 I believe.
List after week. Okay.
Okay.
Item 9.
We'll take it up on second call.
For orders, daily list item 18.
First taking up orders, matters, and then come to admission.
Next.
Yes.
Respondent number 1 to 5 have already entered appearance. Only thing, my lord, respondent number 6 has died and 6A was subsequently substituted. Perhaps, my lord, the service is not complete.
You have taken steps on 5A and 5C. 5A to 5C, have you taken steps?
5, my lord, was already representing, my lord. They were the legal husband, husband and son, daughter.
No, there's nothing on record to show that they have been represented. Otherwise, why would you substitute them? After substitution, you require application to be filed. You are not substituted. You have to take steps.
My lord, IA 3809, my lord, that was for
3809, substitution was allowed, but
Right.
where is the record to show that they have been issued prior notice before this application was taken up for hearing? You never took steps for the advance notice.
my
Respondent number 5A and 5A to 5C. After substitution, they have to be given notice.
I text it.
It appears that pursuant to order passed in IS Civil 3809 of 2025, substitution of respondent number 5 by respondent numbers 5A to 5C was allowed. However, it was allowed by order dated 28/1/2026. Accordingly, the petitioner shall take steps within 2 days for service of notice on the substituted respondent numbers 5A to 5C within 2 days for service of so-and-so, comma, which is made returnable on so-and-so. Next one, office note dated 29/5/2026 indicates that the advocate for respondent 6A has appeared by filing wakalatnama. Next, right. It appears from the earlier orders that when Mr. T. Roy, Bernard Counsel, has appeared for respondent numbers 1 to 4. And respondent number 6A. T. Roy, B. Sarkar, and P. Bhattacharya. P. Bhattacharya, JYA. And for respondent number 6 also, the same set of counsel have appeared. Accordingly, the registry shall reflect the name of the names of certain counsel for the correspondent numbers 1 to 4 and 6-1 in the process for listing the matter next. Next one, list on the your name?
HK Sharma.
Mr. Sharma for the petition. Your name? Oh, sir, you are there. And Mr.
Under 1 to 5.
Tito. Okay. You take steps on 1 and 2.
Yeah.
Sorry, 5A to 5C.
Right.
List on Spencer awaiting service report on respondent numbers 5A to 5C.
Right.
This item 16.
Maybe so.
Oh, I'm sorry. I'm sorry. Just a moment. I think 19, yes. Yes,
So first to note this respondent is all respondent appear also can be fixed for the hearing also.
yeah, therefore, okay. Both sides are represented. The case is ready as regards service and the records are received. Accordingly, this is the matter for Is this an appeal of year 2017? This is the matter for hearing on, give a date, do it after vacation. Hearing on hearing.
What's up?
Item 20. Yes,
He has been disposed of and we have taken steps upon the respondent number 1A to 1D and studies has been completed. An answer has been
1 to 1D.
1A to 1D
So,
for official date of 7/5/2026.
okay. Now, copy of the appellant is present. Office note dated 20 dated 7/5/2026 indicates that notice has been served on substituted respondent numbers 1A to 1D to process server. As per court's order dated 6/3/2019, service on other respondents is duly made. Something is not wrong here. Something is wrong. Please. We have a brief. Please come to the title suit. In title suit, there were 4 defendants and 2 plaintiffs. Correct? In the plaint, there are 2 plaintiffs and there are 4 defendants. Correct? Now come to page 18, the judgment in title appeal. There is only 1 defendant appellant and 2 plaintiffs. So there are only 3 parties. Now in this revision, you have again implemented the others, the respondent numbers 2, 3, and 4. How can they be added here when they were not parties in appeal? You have to take leave because they were not parties in appeal. Correct. That's one. Second is also, you see, we had to look at the record because text was issued in 2023 and the service report has come in 23. Now in 26, we are accepting it. The office note also says that there were direction to take steps by registered post with AD, which we have not taken. Because he is the Kiran Chandra Roy, who is the defendant number 1 who died. He is the plaintiff.
No.
We are the plaintiff.
We are the plaintiff.
The appellant before the you are the plaintiff and the defendant is Ashim Nath and Ajit Nath. Yes. Okay, so they will be represented. Okay. But you will address the court on the next date of this. Okay. Next, it appears from the plaint that there were 2 plaintiffs and 4 defendants. The suit was dismissed. Suit was decreed, my lord, sir. Okay, the suit was decreed, and thereafter the defendant number 1 preferred an appeal, and in the appeal, the appellant is in the appeal, in the first appeal, the defendant is the appellant, and he has arrayed only the 2 plaintiffs as the respondents. So, however, in this memo, the appeal was allowed. The appeal was allowed, and before this second appeal. So in the appeal, again, there are the 2 plaintiffs are the appellants, and the 4 respondents, the 4 defendants have been arrayed as respondents. So accordingly, the non-counsel of the petitioner shall address the court as to whether the parties were not represented in TA number 11 of 2017 can be arrayed as respondents in the present appeal. Next, listed on Monday for considering that considering. They were list on 8/6/2022 for consideration of that said question.
Item 21.
And so substitution is already been it is already presented. And it's on the 6 years.
Take the name of, I mean, call the name of Miss K. Bhattacharya, Charya. Bhattacharya is for respondent number 3 in this CRP. Then give us call for her. Well, wait for some time. You are appearing for whom?
Frequent, for three,
Or just, not required. Not required. He is appearing for 3.
3.1 to 3.4.
You are appearing for them.
Yes,
Where is your Vakalatama? It's not there. You appeared because of submissions of Ms. K. Bhattacharya, the substitution was allowed. But the Vakalatama is never filed. How can you appear without Vakalatama?
Senior the James Arvala was appeared.
No, you see, I'm not concerned with whoever is appearing, but the counsel who is appearing must have the Vakalatama on record.
my lord, on 6/5/26, perhaps, as per my recording.
You have filed Vakalatama.
My lord.
6/5/26.
26.
Not available. Okay. Then counsel for the response, the counsel for the for the petitioner and respondent numbers P1 to P4 are present. Next para, Mr.
H.K. Sharma.
H.K. Sharma, London Council, appears for respondent numbers P1 to 3-4, numerical, P1 to 3-4, and submits that he has filed his Vakalatama on 6/5/2026. The and has produced receipt number 3187/2026, dated 6/5/2026. Next, the registry shall tag the said Vakalatama on record. That's none appears on call for respondent numbers 1 and 2. Next, as the case is ready with our service, this is the matter for hearing on that date we go after vacation. You take back your slip.
Much of it.
Item 23.
Yes.
Yes, my lord, two suits, my lord, filed between the parties, my lord. So for my lord,
Petitioner has not taken steps on respondent number 2,
Yes,
has not taken steps on respondent number 4. So why we should not dismiss the matter?
my lord, by mistake, it was remain, my lord. And my lord, today I have taken step on the formal respondent. True, my lord, today only. I have the receipt.
Govinda.
You are raising the plea of section 10. Where is the previous suit?
Previous is, yes,
122, my lord.
1 of 22.
Yes, my lord. Your lordship will be pleased to find at page number 15.
Yes.
And the subsequent shoot is at page number 27, my lord.
Page number?
27. Subsequent shoot, which is title shoot number 6, August 2022, at page number 27.
Mr. Satar, we can find out an alternative answer. You see, these two suits were filed in a gap of 6 days.
Yes, madam.
Correct. So he may not be aware of the filing of the suit.
True,
Correct.
true.
Now, if a written statement is filed,
Yes, my lord.
then as a defense, they can also take a counterclaim to the same effect. Why these two suits cannot be tried together?
Let it be tried together, madam. I had also tried before the London trial court that because one is before the municip, the other is before the civil judge. Because of the jurisdiction. Let it be tried together. I don't have any objection. Because one is a shoot, my lord, shoot for a specific performance of contract.
Yes,
And the other is only for declaration and recovery of position.
yes,
Recovery of position.
that's right.
If both are tried together, I don't have any objection.
Very good.
Yes.
Man, the prayer is also same, my lord, second.
Yes.
I should have asked both of you first. I would have saved my time. Then this service would be inconsequential. We'll send there and the parties will appear there.
My lord, for the title suit number 6, the first appellate court will be Civil Judge Senior Division 1. And for me, the first appellate court will be before the district
No,
court.
we'll give liberty. We are not passing any order now.
Yes.
See, because of the proximity of the filing of the both the suits, and since in one suit, defense as well as counterclaim can be filed. So the parties will be at liberty to move the court for analogous
Tagging the
hearing
matter to the, yes,
in
madam.
one court.
Yes,
So we are not passing it. It will be considered by the court below. That is what you call the
and moreover, my lord, the order which was passed on, impugned order which was passed on, lord, should not be a barrier to that.
yes.
Yes.
Because there is a reason for doing so. In the suit before the Munsif, Rajan Datta, he is the plaintiff.
Yes.
So, because his case will go to a higher court,
Correct.
so he'll have to make an application.
Yes. He is to make an application. He is to then
For transfer,
he is to make an application
with
before
the district judge for
district
transfer.
judge
For
for
transfer.
transfer in view of your lordship's order.
Okay.
Yes, madam.
Heard Mr. S. Chauhan, and counsel for the petitioner, also heard Mr. A. Sattar, learned counsel, the respondent number 1. Next, brother. The office note dated 21/4/2026 indicates that no notice the appropriate steps has not been taken for service of notice on respondent number 2. However, comma, in view of the nature of order which is proposed to be passed, comma, the issuance of notice on respondent number 2 is dispensed with. Next, brother. The respondent number 1 in this matter is the plaintiff in TS number 1 of 2022, which has been filed on 4/2/2022 before the learned civil judge, Udalguri. Stop. The prayer in the said suit, amongst others, is for passing a decree of declaration that the respondent herein has acquired possessory right, title, and interest over the suit land and for consequential release. Full stop. The said suit having been valued at rupees 6 lakh has been filed before the court having jurisdiction, which is the learned civil judge, Dalguri. Next, the petitioner in this application is the plaintiff in TS number 6 of 2022 that was instituted on 10/2/2022 before the court of learned Munsif at Udalguri. The prayer in this said suit is for issuance of a decree for declaration that the respondent herein has no right, title, and interest over the suit land, and for recovery of khas position for the by ejecting the respondent and for other consequential reliefs. As the suit was valued at rupees 2 lakh, the same is within same was filed in the court having jurisdiction, i.e. the court of Munsif at Udalguri. Next para. The respondent appeared in the proceedings of TS number 6 of 2022 and filed an application under filed a petition bearing number 262/2022 under section 10 of the CPC on the ground that the earlier suit between the parties being TS number 1 of 2022 is pending for litigation before the court of learned civil judge, Udalguri. The petitioner contested the said proceedings and the learned Munsif at Udalguri was pleased to allow the said petition number 262 of 2022 and state the proceedings of case number 1 of 2022 pending before the court of learned civil judge, Udalguri. Next one. when the learned counsel for the petitioner has made his submissions in support of the prayer made in this application, comma, the learned counsel for the respondent has made his submissions to support the impugn order dated 27/5/2022. Next para. In the proceedings before both the suits, the written statement were not filed.
Written objection was filed, my lord.
No, written
But
statement
written statement is
not filed. Next para, on a query of the court, the learned counsel for the respective parties have submitted that in the proceedings of both the suit, comma, the written statement of the defendants were not filed. Next para. Under such circumstances, comma, without finding any fault with the impugn order dated 27/5/2022 passed by the London Municip, comma, Udalguri in TS 6 of 2022, comma, this court is of the considered opinion that the it is to stay the proceedings of case number 6 of 2022 till the pendence till TS number 1 of 2022 pending before the court of learned civil judge, comma, Udalguri disposal. It was court is considered view that the petitioner, comma, is the defendant in TS number 1 of 2022 would otherwise have a right to file his written statement and also make a counterclaim, comma, both the parties would not suffer any prejudice if both suits are analogously tried. To stop. As the proceedings of TS number 1 of 2022 is of a higher value, comma, the proceedings of TS number 6 of 2022, which is filed before the court of Municip at Udalguri, would have to be taken up by the court of higher pecuniary jurisdiction. And the same can be treated as a counterclaim. Next one, accordingly, comma, the court is inclined to grant, comma, as both parties have not stated to have not filed the written statement in the respective suits, comma, the court is of the view that it would be appropriate for the court to give liberty to the petitioner who is the plaintiff in TS number 6 of 2022 to move an application for transfer of the proceedings of TS number 6 of 2022 to the court of the civil judge within bracket senior division, Udalguri, just to be treated as a counterclaim in the proceedings of TS number 1 of 2022 pending before the court of the civil judge within bracket senior division, bracket Udalguri. Post on. Next point, we said, in the event such an application is filed, comma, we request the learned district judge, comma, Udalguri, not to dismiss the application merely on the ground of pecuniary jurisdictions. Of the learned civil judge within brackets in every name, Udalguri to take up the matter. In view of the fact that the suit land in both the suit are same. And but for the pecuniary jurisdiction, both the matters can be tried together. Next part. Mr. Satar, we
sir.
also give a liberty that in the event the petitioner elects to withdraw the suit and to file a written statement and counterclaim,
Yes,
that can also be
yes,
taken upon.
true, true.
Next part.
My lord, actually, he has put the shoot value of rupees 2 lakhs. But if your lordship pleases to peruse page number 30, he
Please
admits
do.
to have taken rupees 6 lakhs from me.
Oh,
So why he has put that 2 lakhs, that is he who is best person to know. Kindly see, my lord, page
now it's like para 8, I have seen that. Para 8.
Yes, page 30, para 8, that on 16/9/2019 at about 8:30 AM, after making payment of rupees 6 lakhs, the sole defendant number 1 forcefully trying to erect boundary wall. So 6 lakhs is already admitted.
His receipt payment.
Yeah, and that was the consideration price. So why he put the value of rupees 2 lakhs in order to make it within the jurisdiction of the municipal, my lord, that is not known to me. But he has admitted in the plaint itself.
In para 7, he also says 3 lakh first, 2 lakh second, and then again so and so.
Yes, part payments were there.
6 lakhs.
Part payments were there.
Okay. Next para. At this stage, the learned counsel for the respondent has pointed out that in the in TS number 6 of 2022, filed by the petitioner, comma, in paragraph 7 and 8, comma, the petitioner has admitted receiving payment of rupees 6 lakh as sale consideration for the suit land. Which accordingly, comma, the learned counsel for the respondent has also questioned as to how the suit filed by the petitioner could have been valued at rupees 2 lakh.
Yes, my lord.
First off, in that view of the, in light of the said submission made by learned counsel for the respondent, comma, as an alternative to the observations made earlier, observations I believe granted earlier, comma, the petitioner would have the liberty to withdraw title suit number 6 of 2022 from the Court of Learned Musif at Udalguri. And as he has not filed an written statement to contest the proceedings in TS 1 of 2022, pending before the Court of Learned Civil Judge, between brackets senior division bracket close Udalguri, he would have liberty to file his written statement and to raise a counterclaim in terms of the pleadings and prayer made in TS number 6 of 2022. However, comma, as it is a suit of 2022, comma, the alternative relief granted shall be exercised within a period of 3 weeks from the date of the order. You are getting now 3 weeks time to get file a counterclaim and then written statement and counterclaim. Or if you want the transfer, you can exercise that transfer also. For analogous hearing.
My lord, Chauhan Sahib is seeking 4 weeks.
4 weeks.
Let it be 4 weeks, my lord, but let it be done.
Yes.
4 weeks from the date of the order. Next, in any event, both the options shall be exercised on or before 4 weeks from the date of this order. Next, the petitioner and the respondents who are both represented shall enter appearance in the proceedings of case number 1 of 2022. Pending before the Honorable Civil Judge, Chennai Division, Udalguri, as well, and also in the proceedings of TS number 6 of 2022, pending before the Court of Municipal at Udalguri, and take such appropriate steps as they may be so advised
Congratulations.
in terms of both the options given by the order. Disposal. Party allowed to the extent as indicated above and matter stands disposed of.
Item 24. Yes.
Yes, Mr. Sahu.
I know. Actually, on the last date of 6th January, the service has been completed.
Okay.
This is relating to the dismissal of the delay condonation petition of the State Commission.
Yes, there is a plea of the lawyer's brief being misplaced.
Yes,
What is to be done?
My lord,
The plea is that the brief was misplaced in the chamber of the learned counsel.
yes.
Are you seriously opposing it? Yes, Mr. Pandit. You are seriously opposing the matter?
yes, I will file the affidavit, my lord.
No, there is no affidavit by yours.
I will file, my lord.
You want to file it?
Yes.
So do it within 2 weeks.
Yes.
Both says are represented on the prayer made by Mr. Pandit,
My lord.
counsel for the petitioner. 2 weeks time is granted to file affidavit in opposition in the matter. List on, give a date after 2 weeks.
My lord, in the meantime, they filed an execution application before the district consumers forum. So that should be,
No, you file an application there.
Yes.
We are taking up only in 2 weeks.
yes, yes, yes.
You have to pray for adjournment.
Yes, sir. Yes,
When is the next date of your execution petition?
I got,
The cathedral feast that will fix in the next week.
Hmm?
And the next week that will,
You can make a prayer for 1 week.
yes, yes, madam.
You are giving a fixed date here. You can
Correct.
take the copy and show it there.
Correct.
Okay. Twenty-five.
Item 25.
May it please the Lordship. Dr. Bride order, office note dated 14/5/26. It is reflected that service on respondent number 2, 3, and 4 was deemed to be served, deemed to be completed. But on respondent number 1, the unserved notice has come back with a comment that no such person was found in the address. Earlier as well, we have taken steps upon respondent number 1. Thereafter, we filed one I for change of address. Then again, we took steps upon respondent 1 in the new address.
The suit was filed by you. And your suit is being stayed from, what do you call this? From the date when it was decreed. And the appellate, what do you call this party degree was set aside. What was the date of that order?
Lordship, here our suit was dismissed for default.
Your suit was dismissed for default,
Lordship,
and then you filed an application for restoration.
yes, Lordship. That was
That was dismissed.
dismissed.
Then you file an appeal.
Lordship,
Appeal was also dismissed.
Lordship.
What do you want us to do?
Lordship, the next course would be for paper publication.
No, it can't. You see, you have given the address at village Rampur. This name normally comes in many movies when they say of Rampur. And there is also a knife of Rampur, very famous. Rampuri Chaku. But the question is that how big is that Rampur? And is it easy to find out, trace out a man just by saying Rampur? It will almost be just like Uzan Bazaar. You are going to find a man, Pawan Goswami at in Kharbuli. Sorry, Kharbuli is too big. Uzan Bazaar. Can you find out?
Not
So this is an address we can't allow you substituted service. We must have the house number,
Lordship,
locality or something.
as per my information, the client has no idea about the proper address of the respondent.
But then can we allow you a substituted service at an address which is impossible to know? Nowadays, even in village with 500 population, people do not know each other. In yesteryears, if you go to a small town, ask people, they will take you there and leave you at the home. But now we don't know. How big is this Rampur? It has to be a big place. The address is not proper. And there is another issue which comes up for consideration. You see, you say that the father, that is defendant number 1, was disturbing you in your position. Correct. Now, according to you, this father has expired and the son is now living in district Siwan, the Rampur at district Siwan in Bihar. Now, how the substituted legal representative would be disturbing your position from Rampur at Bihar if he does not have a house at in Assam? How would he be disturbing your position? You have to say that even after the death, the son came and disturbed us. That's not your case. Yours is a case where you are wanting a decree of declaration that he is threatening you, disturbing your position. So,
Lordship, may allow me to once again make an endeavor to find.
It appears the learned counsel for the petitioner is present. It is noted that notice has not been served on the substituted respondent number 1. Next, however, it is noted that the address of respondent number 1 is only stated to be Rampur, resident of Rampur, district Siwan, Bihar. It does not appear that the said address is a complete address. So under such circumstances, if the notice is not attempted to be served at the correct postal address of the respondent number, substituted respondent number 1, the court cannot arrive at a satisfaction that the respondent, substituted respondent number 1 is avoiding service. Accordingly, the petitioner shall find out the correct postal address of substituted respondent number 1 and next by the learned counsel for the petitioner pays for time because of period is allowed. List after
2
how
weeks.
much time?
2 weeks.
List after 2 weeks, so will try to obtain instructions as to the postal address of substituted respondent number 1. Is there any government advocate present here? No. You are appearing as a government advocate also? No. 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 Yes, Ankarita. Okay. Because you are asking for the government advocate for a different reason. This property belongs to Assam Tea Company Limited, ACTL. ACTL has divested many of the properties to private operators. So we have to find out whether the private operator operating in this particular tea garden.
Lordship, being a additional senior government advocate, Lordship, although I am not interested with this bench, Lordship, but I can take that instruction.
Yeah, that is why this is tea estate called Katonibari Tea Estate at Moriani, Jorhat. This is a property of ACTL. But ACTL properties have been leased out to many private individuals for financial distress of the company.
Yes.
So we would like to have information as to who is operating that tea estate
At
for
present.
time being, because the notice issued was not served. What you call, those served but nobody appeared. But the notice is served on the ACTL. Just try to find out. Yes, that's why Mr. J.K. Goswami and additional senior government advocate present is requested to obtain instructions as to who is operating the Katonibari Tea Estate at Moriani, which is the property of Assam Tea Company Limited, is within bracket ACTL for short. Next paragraph. As is appearing at the request of the court, the registry shall reflect the name of Mr. J.K. Goswami as additional senior government advocate in the causes by listing the matter next. Next paragraph list on. After 2 weeks, give a date because he'll be appearing.
Publish.
Item 26.
Lordship, this matter has become impactful, Lordship. I would like to withdraw this. Because
Okay.
already, yeah, I would like to withdraw, Lordship.
On instructions, Mr. J.K. Goswami, learned additional senior government.
No, Lordship, here I am appearing as
It's a
a.
private, learned government advocate, as learned counsel for the applicant has submitted that due to passage of time, the matter has become infructuous and therefore he has instructions to withdraw this application and the connected RSA.
Yes.
Mr. Fair is allowed. The matter stands dismissed on withdrawal. Stop. Accordingly, the proceedings of the unregistered RSA by filing number RSA oblique 12391 oblique 2023 would also stand disposed of on withdrawal.
Lordship.
27.
May I please before Lordship? Lordship, on last occasion, notice was served upon the respondent number 2. I'm
It is
awaiting for the
already-
service report.
Hmm?
On last occasion, notice was served upon the respondent number 2. I'm awaiting for the service report. Lordship, let the interim order be continued to section 24 application.
No, notice is not served. Where is the order? Notice was served. There's no order. Notice is served.
Lordship, Lordship direction was that to serve notice upon the respondent number 2.
No, unserved notice is returned for respondent with the comment address he left. Postal journal, which is received from the section, is here. It's not served. The counsel for the petitioner is present. The office note dated 11/3/2025. Fresh notice.
Lordship, fresh notice is going to be shown.
You have taken first steps.
Yes, we will take time.
No, this is 2025 is wrong. It should be 2026. 11/3/2025, within bracket 6 SIC. Ought to be 11/3/2025. Indicates that unserved notice is returned for respondent with the comment RTS address he left. Inverted commas, huh? To stop. Accordingly, the petitioner shall the non-counsel for the petitioner shall obtain instructions as to the correct correct and current postal address of respondent. This is not the correct way of doing it. You have taken steps at Dimapur. Correct. And in your petition, you are saying that the respondent is living at Gauhati.
At present, both of them are living at Gauhati. Lordship.
But then why did you take steps at Dimapur? If you know that she is residing at Gauhati, why do you take steps at Dimapur?
Lordship, the present address is Gauhati. At that time, she was residing at
So that
Dimapur.
means while you are drafting the writ petition, this transfer petition, you are aware that today she is not residing here, but tomorrow she would be residing. So your statement in your petition is futuristic.
No, Lordship, when the
You see, you have-
application was filed, that at that time the respondent was residing at.
Don't tell us, because when we are making that statement, that means we have read it and then that's why you are saying. You have made a statement here that she is residing at Gauhati. You want me to find out?
Steps.
You want me to find out that? Come to page 7, paragraph 9. What did you say here? The respondent sought to show she is presently residing at Gauhati. You see, we got time yesterday, we got 2 days time to read this, all this. So I read everything. Even inside we go and read. So your taking of steps is incorrect. Don't do that.
Lordship will take fresh steps now.
You take it at the proper address. Miss Yunanda, I'm counsel for the petitioner.
Lordship, I am not Yunanda, I
Oh,
am
acha.
D. Chakravarti.
D. Chakravarti, learned counsel for the petitioner, shall take steps within 2 days for service of notice on the respondent at the Gauhati address, because in paragraph 9 of this application, it has been mentioned that the respondent is staying at Gauhati. The notice is made returnable on so and so.
Lordship, let the interim order be continued.
Okay, interim order passed earlier stands extended till the next date of listing.
Grateful.
Yes, item 28.
My lord, this matter, my lord, in the during the interim period, my lord, there is a survey report, my lord, which has been already submitted, my lord.
We'll have to dismiss our application. You don't take steps on respondent number 2 to 4. And therefore this matter is pending for no reason at all.
My
If you
lord,
don't want to take steps, we dismiss the application.
I'm sorry, my lord.
It's a 2024 petition.
My lord. My lord, I will take steps, my lord. I'm sorry, my lord. I can skip, my lord. Today itself, my lord. It's a government council, not even serve the office.
Where is the plaint? Plaint is at which page?
My lord,
Plaint is at which page?
plain they have not annexed. Plain they have not been annexed, my lord.
Okay, you have a copy of the plaint with you?
My-
This petition was filed by whom?
So by one of the, my lord,
No, this petition where this order 26 was passed was filed by whom?
by the department, my lord. By the defense ministry, by the Union of India, my lord.
By the Union of India.
Yes.
You have a copy of the plaint?
Copy of the plaint is not available, my lord. By the annexure 3, my lord, that order, my lord, there was a direction for conducting the survey, my lord. Page 25, annexure 3. The operative part is at page 31.
This petition number 694 was filed by whom?
Filed by the
Page 25.
petitioner,
Huh?
filed by the
Filed by
petitioner,
the-
Union of India.
Union of India.
That's the problem. You have a copy of the pen? No.
No. Paragraph one, my lord, I have mentioned the pair of the plaintiff, my lord, in the suit.
No, you see, will not understand anything, notwithstanding that no steps have been taken. You now say that there's a digital map which has been approved, and you don't even produce that. How will we understand
No,
that
my lord,
you see, number one, how much is the land which is rest to be enclosed? We don't know the measurement of the land which is covered by this DAG number 72 and
Now, my lord,
72, 74.
my lord,
The question is very simple, that whether the defendant defense has encroached any portion of land of Jalaluddin.
that
So
was
that-
my lord, subject to a survey report. Now, that report has come now, my lord, because the trial court has proceeded without the report. My lord. Although the survey was conducted, my lord, but without waiting for the report, the court has fixed the matter for final argument. That was, we have challenged, my lord. Now, my lord, during the pendency of the present proceeding, my lord, the report, the final report has come, wherein, my lord,
Where is that?
that is here.
If you're relying on these things, why don't you produce it? It unnecessarily causes us this is the time
My lord, during the pendency, it has,
we understand, but you should bring it here. When you see that I am going through the records and trying to find
No,
out why this was not made a part of the record, we'd have understood what has happened. Instead of starting from the plaint and then asking for this and that, you could have known what is happening.
page 4.
Again, this does not show anything. Whatever is relevant is not there.
Page 4, my lord. Page 4 is the letter dated.
Goswami was here, just give a call for J. Hendik Revenue, SC Revenue. Nine. We don't know how the documents are being handled by the state officer of the army, we don't know.
My lord.
This is the defense land.
Yes, my
We
lord.
are accepting this document. The court order is to is on this doc number 48,
My lord.
49 and 50,
Yes,
correct?
my lord.
Now, in this document you are producing is only the chitta of 49 and C95. So nothing what is essential is before us. We don't even have a basic information as to how much land is there in this doc number
That
48.
is the page number 4, my lord.
Page 4 is doc number 49. How do you want me to read it when I'm asking for
My lord, the
48?
letter dated 11/7/2024.
You see, letters I don't read.
No.
When we have the land records with us,
No.
we are looking at the land records which is in the next page.
Yes, my lord.
So this is 49. So how will I find 48?
My lord, if my lord can see, my lord, it is 47, 48, 49 and 50.
Does it say 49 means 48 and 50 also?
My lord, Vartaman Nutun Dag. My lord, it is written, my lord. Upayut. Old Dag is, my lord, 13. Onko Mut Mati.
73, 72, 74, 77.
These are old, my lord. These are old. Thereafter, my lord, it says Onko Mut Mati. My lord.
Bottom Nutun Dag 48, 49, 50.
Yes.
But here you look at the first row column. This is 49. Here. Look here.
Yes, my lord.
This is 49.
49, my lord. Yes.
Then
No, this is the report by the revenue, my lord, given to us. My lord. I will verify it, my lord.
bottom Nutun Dag 48, 49, or 50.
Yes,
So and so, but where is the alteration of this all the 3 dag into 1 dag? That doesn't say so. Without understanding how to produce this document before the court.
no, this is given to us, my lord. This is a communication.
You understand? And you accept the documents and present it before the court without even reading it.
No. No, I have received it in recently, my lord.
I understand, but before producing, you must understand the document before producing. It doesn't show anything. The court direction is 48. So let that happen. What is so secret about this defense land when half of the defense land is road, half of the land is occupied by Jalaluddin? What is your question of secrecy there in that land?
No.
You can't occupy a private land and then say it's very secret.
It is not private. That is what the question was, my lord. That survey was
That's why
to be done to find
even
that.
before us, you are not producing anything.
My
You
lord,
are the defense organization. You must have the records of what is the land holding with you.
my lord, this letter, my lord, I am just placing, my lord.
You see, letters don't help us. If letters would have helped, we would not have asked for a survey report.
No.
The survey report does not say even what is the area of land which is
No, it is
under.
for the revenue authorities to do that survey, my lord. That is why that survey was called for. In fact, we wanted the clarity, my lord. The defense,
Then why you challenged it?
we have not challenged it, my lord. Without waiting for the survey report, my lord, the matter was fixed for final hearing. In spite of being there is a specific order by the court to do the joint survey, that this is the order which is under challenge, my lord. Page,
Where is the previous order?
page 44 is the impugn order, my lord.
No, the original order where the survey report was
Yes,
asked for.
that is
Page 25,
25.
25.
No.
relevant page 30.
Okay, and after that, what has happened?
After that, my lord, the impugn order was passed, my lord, at page 44. Forty-five is the relevant question of considering the
Mr.
circumstances.
Vishwas, this should go back. It has to go back. The defendant is only seeking an adjournment. Like, if this prayer for the adjournment was not sought for by the petitioner or the defendant, the 1A and 1B, what would have happened?
The only ground of rejecting the prayer was that
Defendant is
multi-
taking time after
yes,
time.
multiple opportunities were
But
given.
the survey report, you see, circle officer can't be produced by the army.
Yes. It may be disposed of with a direction, my lord, to granting a last chance to submit the
Unless we say that the defense can shoot at sight. If the defense, the circle officer is not acting. Then obviously that order we can pass.
But some report has come, my lord, let the state clarify, my lord, whether they have submitted the final report, sir.
No, you'll have to do it in this suit. Why would we ask for that? We are calling for them for a different purpose altogether,
No.
not for this report. We are not taking up trial to ask for the report. You just gave us the report, and since there was no affidavit, we started reading it. And we found that doesn't satisfy our requirement. But if the defense estate officer is happy with this report,
No, we are
we have nothing to comment.
We have just received the survey report.
I
I will
understand.
take instruction.
No, don't say just received. It is 20 June 2025.
No.
If this 2025 report is being given to you just now,
We have communicated.
then also you can request the Home Ministry to give award to those people.
No. Well, I will take instruction over whether.
No,
the
request the
department
defense-
accepts the survey report.
Request the defense establishment to give award to those people who give you instructions of 2020, June 20, 2025 letter
The
to
matter,
you just now.
matter listed under now, earlier occasion.
All these people should be elevated to very responsible posts where they can delay everything. Obviously, you don't want a funny comment from the court. If you are ready to accept it, then we are ready to give it.
The matter is listed after 4/11 today only, 4/11/24.
Then that is not the
The last-
issue of the court.
No.
I would have sent the matter for usual hearing, but we are taking up hearing. Why? Since the suit has been stayed, we are taking up the hearing.
My lord.
So don't tell us that this is pending for, it's come after 1 year or 2 years. Even if it has come after 2 years, we are ready to hear it.
My lord.
Are you ready to assist us?
Yes, my lord.
Then we dismiss the application. If this is the document produced, why should we send it back?
No, the report has come, my lord. The court will not take into consideration the survey.
It will not come, because if we are not satisfied, we will not allow this to come to on board. You say you are ready to assist us, then do assist us.
So our grievance was, my lord, that the report.
Please tell us, how does this help the court? We have a report here.
My lord.
How does it help you? How does it help the respondent?
But that is the revenue authorities to say, my lord, then they.
That's
Yes.
why we said that, but you said that, yes, you are ready to assist us for the hearing.
My lord.
Don't understand the documents, don't accept it. Without any instructions, don't accept the documents. Nobody has asked the government advocates or the CGs to accept document without understanding. That is not how you assess the court. Had I not read the orders, I would not have understood anything. I would have believed on the letters written by authorities. How does it show anything? Doesn't show anything. Third, Mr. H. Gupta run its CGC for the petitioners. And Mr. S. Biswas run its counsel for the respondent. Next paragraph. In view of the order which is proposed to be passed, issuance of notice on the respondent number two to four is dispensed with. And you see, the nature of your assistance, when you use that word, I am retaliating, otherwise I would not have. The respondent numbers 2 to 4 are State of Assam, Deputy Commissioner and the District and the Circle Officer. You can't even give extra copies to the government advocate. The court says take steps and you can't take steps. And then you come and say that we are ready to assist you. This is what how you assist. Not even taking steps to the government. It is not how you assist.
I'm sorry.
Be mindful of whatever you are saying.
I'm sorry that mistake.
Stop. Although the respondent numbers 2 to 4 are to be represented by the government, but no steps has been taken till date. Next paragraph. The learned civil judge within bracket junior division Solitpur, Tejpur had passed an order dated 18/1/2024 in connection with PS 106 of 2014, by which petition number 694 of 2023 for conducting joint survey to a commission was allowed.
Rejected, my lord.
That was rejected.
Yes, my lord. Page 30.
No,
Hence the
it is
petition
allowed.
Hence the petition filed by the petitioner defendant number 1A is rejected. However, at the greater interest of justice, my lord,
Okay, but you are right. Was rejected. So, however, the greater interest for shedding light in the matter, joint resurvey of the suit land was still allowed. And the State Learned Court, in exercise of power under Order 26/9 CPC, directed a fresh joint survey of the concerned land in presence of both the parties by directing the circle officer, Thelamara Revenue Circle, to conduct the joint survey, and the defendant numbers 1A and 1B were directed to bear the necessary cost. Full stop. As per the writ of commission issued, next paragraph, the direction to the circle officer to execute the commission for survey of land was in respect of the following 3 points. Page 32. A, B, 1, 2, and 3. Pencil mark. Full stop. Subsequently, as the survey commission report was not received, the petitioners, by petition number 1350 of 2024, paid for an adjournment as the Thelamara Revenue Circle Officer could not send the outcome of the survey due to flood scenario prevailing in the revenue area, in the concerned revenue area. However, the learned civil judge within bracket junior division bracket was 1, Sonitpur, Tejpur, by order dated 6/7/2024, in view of the adjournment taken by the petitioner, deemed it appropriate not to keep the case pending solely for the report of the commissioner, and accordingly directed the parties to conduct argument in the matter by fixing the next date on 6/8/2024. Next one. Agreed by the said impugn order dated 6/7/2024, passed in TS 106 of 2014 by the learned civil judge within bracket junior division, bracket 1, Sonipur, Tejpur, in TS 106 of 2024, the present application is filed in Article 227 of the Constitution of India. Next paragraph. Although the learned counsel for the respondent has made a submission in support of the impugn order in view of the inordinate delay in disposal of the suit, however, the court is of the considered opinion that the learned trial court, having rejected petition number 694 of 2023 for joint survey of the defense land, had passed a suo motu order on 18/1/2024 for conducting a joint survey of the resurvey of the disputed land and issued a writ of commission for survey of the land pursuant to order dated 18/1/2024, the said learned court ought to have allowed the survey report to be placed before the court. Next, if there is a delay in the execution of the writ, it is not by the defendant, by the petitioners, but it was the circle officer, Thelamala Revenue Circle, who had delayed the commission of the commission report. So therefore, this is not a case where any delay can be attributed to the present petitioners. So even if the petitioners would not have filed adjournment petition by petition number 13550 of 2024, still the learned trial court, having issued the commission, would have to pursue the same. Next, the court is of the considered opinion that as the petition filed by the petitioners was rejected by order dated 18/1/2024, they would have been precluded from filing a fresh application for commission. The learned trial court, having issued a suo motu direction for commission for survey of the part of the defense land covered by the Act number 48 within bracket new, 49 within bracket new, and 50 within bracket new, Pata number 46 of village Lakhu, LAKHU, PARA, Mosat Moja, Lisa Mari, MI, SSA, MARI, comma, under Thelamara, THELA, MARI, Revenue Circle, comma, the set part of the order dated 18/1/2024 requires to be brought to a logical conclusion. Next paragraph. The learned civil judge within bracket junior division bracket close number 1 Sonitpur. This is a learned trial court had the power to compel compliance of the orders passed by the said learned tribunal. The said learned court. This one. Which does not appear to have been taken. Next, under such circumstances, comma, the impugned order dated 6/7/2024 is not found sustainable. Next para. In the meantime, at this stage, the learned CEC has submitted that he has been informed by instructions dated 26/2025 that in the meantime, the circle officer, Thelamara Revenue Circle, has given a report. Next para. If that be so, comma, the learned trial court shall issue direction on the commissioner to submit the report to the said learned court. Next para, the petitioners and the respondent who are duly represented command directed to appear before the Court of Learned Civil Judge within bracket junior division bracket close number 1 Sonitpur Jodhpur on yes. How much
Any date,
time?
my lord, 8 or 9,
Of June.
June, my lord.
Okay. He'll have to make communication. We'll make it 10th then, 10/6/2026. And on the date, comma, the parties on the petitioners, comma, on production of a certified copy of the order shall await for further instructions, for further directions to be passed by the settlement court. Next para. Actually, before this, you will have to write that one paragraph before this, you have to say that according to the impugned order, dated so and so, passed by so and so, is hereby set aside. Okay. Petitions and allowed to the extent as indicated above. There should be no orders to cost.
A time frame may be fixed for, my lord, this, it is at the stage of argument, yes. Otherwise, the next time the report is not submitted, the same thing will be repeating, my lord. Some reaction to the circle was. Yes. Yes.
Obliged.
Much obliged.
Was a bit late.
For orders, item 30.
In this case, I appear for the sole respondent.
Yes.
Earlier, a prayer was made for submitting objection against the petition for condonation of delay, my lord. But due to some unavoidable circumstances, that step could not be taken in time as granted by this honorable court. My lord, may I pray for some more time because party has instructed me to submit, because
Earlier
No,
advocate has been
Mrs.
appointed as a APC.
No, Mrs. Chaudhary,
APD.
Mrs. Chaudhary,
And
see, English is a beautiful language. Sometime would also mean time by hours. Sometime would also mean time by calendar days. So what do you want?
Lord, my associated counsel, he has left the practice to join as
No,
additional.
I understand, but time by hours or time by calendar? What time do you want?
Only 2 weeks, my lord, only 2 weeks.
2 weeks will be too long.
And the instructions.
Okay, but Mr. B. Chakravarti, now counsel for the applicant is present. And he presses for the prayer for condoning the delay. Next prayer. Is B. Chaudhary, now counsel for the respondent. Has prayed for 2 weeks further time to file the objection. Next para is already prayer is considered and allowed. There's a last chance. Next para, this term, give a date after 2 weeks. You're giving a fixed date this time.
Obliged, my lord.
Item 31.
May it please also, it is condonation of delay application, my lord. Is 68 days in preparing the second appeal, my lord.
That is too large a time. What is your explanation?
Explanation is that, my lord, during the pendency of the appeal, my lord, the first appeal, the appellant died, my lord, and his name, legal layer's name has been substituted. By the mistake, my lord, while preparing the, my lord, in the impugned judgment, the name of the legal layer has not been reflected, my lord. Therefore, we have filed another application for, my lord, correction of that judgment, my lord. Ultimately, the
Just a moment. You said that the appellant died during the pendency of title appeal.
yes,
His name was substituted, but there was an error in
yes.
carrying out the substitution. So the correction was done when?
Correction was done, my lord. I have annexed the order copy, my
Just
lord.
tell us the date.
It was done by application of
5/7/2022, my lord.
Huh?
5/7/2022.
This is the order of correction was done.
Yes, my lord.
5/7/22.
If that is 2022,
And he died on, my lord, 18/1/2022.
18/1/22,
Yes.
but this order is preferred against the
23.
judgment and order of 23/8/2023. So that substitution is a gone matter.
Yes, but
Substitution is, the delay in substitution doesn't affect us. Your time will run from 2023. And what is the ground for not being able to file the appeal on time?
because name has not been corrected in the appeal, my lord.
Huh?
The legal layer's name has not been reflected in the judgment, my lord. Therefore, we have filed an application to correct, my lord, to correct it.
What is the order?
My lord,
What is-
kindly, that order was annexed in the appeal, my lord, appeal memo,
Just tell us, it's a simple thing. You will have to just
On-
tell 1st January, just
17/8/2024.
17/8/24.
2024.
Which page of the revision, appeal is that?
That's page 61 of the appeal memo, Lord Sir.
61.
Last paragraph, my lord. In the light of the petitioner respondent contention, it is evident that the court during the pendency of the judgment overlooked recording of the name of legal heirs Anwar Hussain, which were already present in the memo of appeal. Therefore, the error appears to be purely typographical and can be corrected under 152 CPC. In conclusion, the court allowed the petitioner prayer directing the name of the legal heirs of the deceased Anwar Hussain be inserted in the judgment. It is 17/8/2024 order, my lord.
You have a copy of the decree with you?
Decree part, my lord, that is,
So the appellate degree, first appellate degree, is it available?
no, my lord. I don't have that copy, my lord, because when I have applied it, certified copy, my lord, they did not prepare the decree, my lord, at time. Subsequently, my senior counsel has, my lord, filed an objection to my petition, my lord. They have annexed, my lord, that is page 57 of the objection, my lord. Believe I can explain in the paragraph 4 and 5.
Yes, Mr. Siddharth.
My lord, if I can take your lordship to his memo of appeal, and that to my lord, page number 35. So I will take your lordship to memo of appeal at page number 35.
Yes, memo appeal.
Yes, page number 35. As against this memo of appeal, my lord, he has filed the RSA. And there appears no correction of the name, and the copy was obtained on 16/11/2023. But while he made an application before this honorable court under section 5 of the Limitation Act, I have made, my lord, an objection to that. And to that objection, my lord, if your lordship pleases to peruse page number 31
Of the objection.
of the objection. Page number 31.
Yes.
All the corrected names at the left-hand side of the judgment, my lord, appears. So what compelled him to file the appeal, RSA, without the correction, without the corrected copy, my lord? And now he is saying that there is a delay. of 368 days or 300.
No, that order has been.
No, you see, there is a small issue there. This correction, if you read page 31,
Yes, my lord.
is,
By deleting the name of.
no, not that, the date of the civil judge is 23/1/25. Or 20, what is the date? It is 25 or 23?
23, my lord.
The correction was made later on because the order passed on to 24th. When we have applied, my lord, that correction was not made. Therefore, we have to file under 152 application, my lord. And therefore, the first appellate court has
And
filed the
this correction,
17th.
there are two dates, Mr. Satar.
Yes, my lord.
One is down below.
Yes,
This is 23,
23/11/23.
23/11/23.
Yes,
But the next signature is civil judge number 1 on 21/9/24. There are two signatures.
yes, my lord. Kindly peruse that the following names of legal heirs of the deceased Anwar Hussain, written by pen,
Correct.
is inserted in the title of the judgment by order dated 17/8/2023.
No,
Yeah,
17 2019 or 18.
Hey, original copy to you. My lord, when the judgment is pronounced on 23/8/2023, then correction cannot be before that. It is 23, my lord.
No, there has to be correction has to be made after 17/8/2024 when the order.
No. The following names of legal heirs of the deceased.
Right, judgment and order dated 17/8/2000. Is 18 or 19?
2023, because the judgment itself is, my lord, 23rd of August 2020.
No. In the title, okay. You are right. You have a point. It has to be 23.
Yes, my lord. And that's why down below the pen handwritten 23/11/23 is the date given by civil judge number 1, Kamrup Metro, Gauhati.
We will call for the trial court, the appellate court record.
Lordship.
My lord.
Because if there is a error in the,
My lord, even my lord, that 152 application, my lord, the order for correction was made on 17/8/2024.
what is the page number?
Page number 63 of my appeal memo, my lord. That correction cannot be made prior to 17/8/2024 because there was no correction.
Correct. Parties are represented.
Let the record be called for me.
Oh, just a moment. Let us see this.
Because my lord, substitution was done, my lord. in the-
Just a moment.
On 5/7/24. But did not correct the cost title. Therefore, we have to find this application.
Oh, no, there is an admission, by the court that it was an error.
Yes,
So this order was passed on 17/8. Then he has an excuse. If it is 17/8 and the appeal is presented, this appeal was presented here on 26/11/24. There will be only 9 days of delay.
Delay is, my lord, 260 days, they are saying.
No, that's okay. But if that correction order from
Yes.
17/8/2024, the appeal was filed on 26/11/24 before this court.
Yes.
So 90 days for appeal. So it goes only 9 days beyond that period of limitation.
My lord, let the record be,
No,
because
it's
otherwise
not-
also the
it will
record
have to be
shall,
called for the record.
yes, otherwise also the record shall have to come for final hearing.
No, but normally in a condonation application, it's never called for. Once these orders are very clear.
It's on the face of the record itself, my lord, there's nothing to hide again, my lord. Because already by substitution application, the court has admitted in 2022 order was passed, my lord, but that was not corrected.
In page 63, Mr. Satar, paragraph 6, the court admits the mistake.
Paragraph number?
Paragraph 6 at page 63.
Appeal minister, that's not correct.
The court has admitted the mistake.
Okay.
63, right here.
Once the court admits, we'll have to accept it.
My lord, may I read, my lord, that?
Yes, is para 6.
In the light of the petitioner's respondent's contention, it is evident that the court, during the preparation of the judgment, overlooked recording the name of the legal heirs of Anwar Hussain, which were already present in the memo of appeal. Therefore, the error appears to be purely typographical and can be corrected under section 152 of the CPC. In conclusion, the court allows the petitioner's prayer directing that the name of the legal heirs of the deceased Anwar Hussain be inserted in the title of the judgment. The miscellaneous case is disposed of. It is the order dated 17/8/2024.
So from there, the appeal is filed on 26/11. You record your objection. Hi. Mr. Chiladitel, counsel for the applicant. Also heard Mr. A. Satat, counsel for the respondent caveator. Next, Parag. By filing this application under section 5 of the Limitation Act, the applicant, who is the appellant in the connected appeal, has paid for condoning the delay of 368 days beyond the period of limitation in filing the connected appeal. Next one. Reason assigned for the delay is that though the certified copy of the impugned judgment was obtained on 16/11/2023, which is annexed to the memo of appeal, but it did not contain the name of legal representatives of the deceased appellant, whose name was ordered, who had died on 18/1/2022, and whose name and whose legal representatives were substituted by order dated 5/7/2022. To stop. Accordingly, the appellant, the applicant, filed an application, filed a petition which was registered as petition number 5669/24 for praying. No. When was your application filed?
They were registered as Miss J, my lord, Miss J case number 959/23.
Okay. You present filed an application for correction of the court title of the memo of appeal. in the judgment and decree, Mr. Said application was registered as Ms. case number 959 of the 2023 in connection with TA number 69 of 2017 and the learned civil judge within bracket senior division, bracket code number 1, Kanpur Metro, Gauhati, by an order dated 17/8/2024, admitted the overlooking of recording of names of the legal representatives of the deceased appellant Anwar Hussain, whose names were already present in the memo of appeal. Mr. Accordingly, holding the said error to be a typographical error, was corrected by applying section 152 of the CPC. And accordingly, the names of legal heirs of the deceased appellant was brought on record. And the said Ms. J case number 959 of the 2023 was disposed of. Stop. Accordingly, it is submitted that when submitted by the Land Council for the applicant that this petition was filed on 26/11/2024, which is after the passing of the order dated 17/8/2024. Next slide. The Land Council for the respondent has immediately opposed the prayer for condoning of the delay. Has submitted that as the legal representatives of the appellant was already implemented by order dated 5/7/2022, and the appellant had applicants had obtained the certified copy of the judgment on 16/11/2023, there was no impediment for the appellants to file the appeal, and annexed with it the copy of the order dated 5/7/2022 allowing amendment, allowing substitution. Mr. Accordingly, it is submitted that there were clear delay and lapses in filing the application on within a reasonable time of passing of the judgment and decree. Accordingly, prays for dismissal of this application and the connected appeal. Next paragraph. It is noted that the applicants had applied for the certified copy of the first appellate judgment dated 23/8/2023, passed by the learned civil judge number 1, Kanpur Metro, Gauhati on 3/10/2023. And the certified copy of the first appellate judgment dated 23/8/2023 was provided was made over to the applicant on 16/11/2023, and thereafter preferred an application for correction of the judgment and order, which was registered as Ms. J case number 959 of 2023. And that the said Ms. J case number 959 of 2023 was allowed by order dated 17/8/2024, whereby the learned first appellate court had admitted the mistake of overlooking the name of the appellants, which was already on record. Stop. The next paragraph, therefore, comma. as the this case, BC case number 959 of 2023 was filed in the year 2023 itself for correction of the first appellate, the cost title of the first appellate judgment and decree, judgment passed on 23/8/2023, comma, the time which was spent in pursuing VJ case number 959 of 2023 is a good and sufficient reason which has explained the delay from the date of passing of the interim judgment and the consequential correction of the order by, sorry, judgment by order dated 17/8/2024. Therefore, the delay appears to be only 101 days from the date of passing of the order dated 17/8/2024, by which the judgment dated, first separate judgment dated 23/8/2020 was corrected. So therefore, the period of limitation, the opinion of the court would run from the date of the correction, which is 23/8/2023, according to the out of 101 days delay, 90 days is available for filing of the appeal, and therefore delay should only be 11 days beyond the period of limitation in filing the appeal. Next, for the reasons as discussed above, the court is of the considered opinion that the applicants have been able to show good and sufficient cause causes which has caused the delay in filing of the connected appeal. So according to the delay of 368 days, which is actually found to be 101 days, 11 days only, as indicated above, and stands condoned. Next, the registry shall now register the connected appeal, and is the same for hearing under Article 41, Rule 11 CPC.
Item 32.
Text was fixed.
For, no, it can't, they'll have to register it again. This always will remind you of there's somebody about. You have to make fails also. Yes, 32.
May I please, Lord? The service upon sole respondent is complete. Matter will be posted for hearing.
Just one. You served it by Dusty.
My
You're referring for
Dusty by way of the
Okay. Mr.
D. Mazumdar.
D. Mazumdar, and counsel for the appellants, and Mr. A.R. Kalita. A.R. Medi, I'm sorry. Eleven counsel for the sole respondent. Stop. As the case is ready as regards service, comma. You, This is 2025. It cannot be posted for hearing now. You say, give a date after vacation.
Yes,
For fixing of a date for hearing. List on so and so. So as to enable the court to fix a date for hearing in the matter.
Sir, there's an interim order passed in the IA. That may be extended. The interim order of status quo.
Okay, the order passed in IA Civil 1560/2025 stands extended till the next meeting. But you're listing on another date because right now we cannot fix a date for hearing in 25 matters.
Much older.
Yes, 33.
Yeah, please, Your Lordship.
Yes.
Your Lordship, as per office note dated 27/10/25, service has been completed, but LCR has not been received.
You are appearing for all
Yes,
these
sir.
comments. Okay.
Your Lordship, as per order dated 18/8/25, this RSA should have been listed with RSA 103/25. But the same has not been
With RA,
yet.
RSA 103.
Yes, Lordship, should have been listed along with 103, Lordship.
So it is 103.
It is 100/2025, Lordship. This RSA is 100/2025. This RSA should have been listed along with RSA 103/2025.
How do you understand?
But the same has not been tagged yet, Lordship.
Okay. Okay, both sides are represented. Your name?
B. Hajarika.
Ms. B. Hazarika, and counsel for the appellant has referred to the order dated 18/8/2025
Yes, Lordship.
and says that the matter be listed along with RSA 103 of 2025. She has also submitted that the records of the court, that the TCRs have not been received. Next para accordingly. The registry shall issue a fresh reminder for the TCR relating to the trial court and the first appellate court. Next para. List on so and so, awaiting receipt of the LCR, TCR. So the registry shall list the matter along with RSA 103 of 2025 as per order dated 18/8/2025. List on so and so.
Okay.
After 4 weeks for the records. Item 34.
May I please, Your Worship?
Yes.
My lord, a title suit was filed bearing number 95/2012, which was decreed on 25/4/2024, my lord. And an appeal was filed after that with a delay of 170 days. That was registered as misdemeanor case number 159/2024.
Just a moment. Mr. Supra, please give the dates again.
My lord, the judgment was passed on 25/4/2024 in TS number 95/2012.
TS 30.
TS 95.
95 of 2000.
12, my lord.
Yes.
Now, my lord, there was a delay in filing the appeal appeal was filed as title appeal number 72 of 2024, along with a delay application for condoning the delay.
Yes.
My lord, while filing that appeal, there was a delay of 170 days.
Ah.
Now, my lord, when the notices were served, then from the Jari Karak, the present plaintiff petitioner came to know that one of the respondent number 10 has died. Then
You are the appellant.
I am the appellant. I am the appellant. I lost my case there in the lower court.
Okay. Respondent number 10 had died.
Yes.
Therefore, appeal was filed against a dead person.
Appeal, we never knew that he is dead.
It's okay. It was
Yes.
filed against a dead person.
Yes, yes, my lord. Then my lord, we made an
He died
application.
when? What is the date of death?
Date of death, my lord, is not known to me.
Not known.
Jari Karak only did.
Okay.
Then, my lord, we filed another application, which is number 49 of 2025, for substituting the name of his legal heirs.
When did you file it?
This was filed, my lord,
That BJ 159.
which 159 was under section 5 of the Limitation Act.
For substitution.
Yes. And another mistake was filed, my lord, on, that is under order 1 rule 10 to 49 of 25.
No, you said 49 or 25 is 170 days delay.
No, delay 159/24 was for condoning the delay, my lord.
This one.
BJ 159 of 24.
Okay. So this is BJ case for 49 for order 1 rule 10-2.
Yeah, my lord, we served the notice of BJ case number 159 because without the delay condonation, appeal cannot be admitted. So, meanwhile, the Jari Karak reported that
Something is wrong. You said that 159 is the substitution application.
no, 159 is the delay condonation application. my
Delay
lord.
condonation application. Yes.
Then, meanwhile, it was reported that respondent number 10 has died. So we filed an application under order 1 rule 10-2 that was registered as
49 or 25.
yes, my lord. My lord.
Okay. So what happened then?
Yeah, my lord, the learned first appellate court passed the order on 30/7/2025, and that your lordship will be pleased to see.
BJ 49 was rejected.
Yes, page number 49, my lord.
Yes. You are objecting to the affair.
Yes, I am appealing for respondent 123.
What is your objection?
Proceed here, I do not have any proper instruction regarding this case because it's an anonymous appearing in this case.
No, nobody will give you instructions. This is a pure question of law.
Proceed.
Whether substitution would be under order 22 or it would be order 1 rule 10 is a pure question of law. And don't, what do you call, just in a writer note, not to speak of the clients, even we find at times difficult to choose what is,
Yes.
what we write. Will it be order 22 or it will be order 1 rule 10-2? So in fact, there are several judgments of Supreme Court which says that if the person dies during the pendency of the appeal, before the appeal is filed, then order 1 rule 10-2 is permissible,
Yes.
also in a suit. Yeah, what judgments, I think?
Yes, my lord, I have. My lord, machine is not working. My lord, I had
Not
asked him-
working.
একটু লিখে যাবেন।
Okay, but I have it. This is.
So, my lord, two miscellaneous applications were lying before the first appellate court, my lord. Now, out of those two, only one is disposed, stating inter alia that order 1 rule 10(2) is not applicable. So, when, my lord, when the very delay condonation application is, delay is not condoned, the learned trial court or the first appellate court ought not to have been taken any other application.
So
So,
that goes, but order 1 rule 10(2) is a correct application.
yes.
So
So, my lord, if I can take your lordship to page number 49.
first of all, he's a young lawyer. Is he prepared? I'm not prepared also. You're not prepared. We'll take it up day after tomorrow. Be prepared by then. Correct? It's a question of pure question of law. No facts are involved here. He give you an opportunity, Mr. Sudha.
Yes,
He must,
yes, yes,
he must be well equipped to fight with you.
yes, yes, my lord.
What is the SFL and counsel for the petitioner and Mr. Your name?
Essay Bhatia.
I say
Bhatia.
Bhartiya and counsel for the respondent.
Respondent 1, 2, and 3.
Respondent numbers 1, 2, and 3. Next, brother. On the pair made by and counsel for the respondent list again on 310, 3/6/2026.
My humble prayer is logic can be listened on Friday also.
Friday. Okay, fine. 5/6.
Friday, okay. Oblige.
Not so much.
My lord, item number 32, my lord, they have filed a missed case, but they are not servicing any copy or any order to me.
But they are left, where are they?
Actually, when I am checking this petition,
You can call him. They will, you take for the record, their telephone numbers will be there. Just call him. He's calling because he has left. We can't do anything now.
Lord,
It will file to brief for number 2. Finally.
Item 36.
so perhaps the answer of notices returned back.
This lot. It will. I return actually. Acha. You have to find out the correct address now. The house is always locked.
Yes, sir.
Okay. In view of the note, office note dated 23/10/2025, comma, the Mr. R. Chakravarti and counsel for the petitioner. For the applicant, Respondent is granted 2 weeks time to ascertain the current postal address of the sole respondent. Next one, based on due date after 2 weeks. Yes, 37.
All right.
Item 37.
May it please your lordship. Lordship, as per office note dated 18/5/2026, lordship. Uh,
Did you produce a copy of the order before the concerned court, district judge? Did you produce the order dated 30 March before the district judge, Hailakandi?
Hailakandi, lordship.
Have you submitted the certified copy?
Yes, yes.
Yes or no?
Some time may be granted, lordship.
No, it's not a question of granting time. I'm asking a simple question. Have you submitted the order of stay before the trial court? How do you expect the trial court to stay the proceedings if you don't produce a certified copy of the order? The proceedings are stayed. How do you expect the trial court to know about it? Perhaps they are not receiving it because by the time effective orders have already been passed in the suit. Okay. Your name?
J. Ghosh.
J.
Ghosh.
This J. Ghosh, Land Counsel for the petitioners. As per the office note dated 18/5/2026, comma, in respect of the process service report, comma, it is mentioned that as per that the process server could not find the person in the respondent in the given address, and the local residents have informed the process server that the respondent had left for Bangalore 7 years earlier. Full stop. As per the notice issued by Speed Post, comma, the registered letter has been returned back with the remark refused return to sender. But we don't understand this. You want the transfer of the proceedings to which place? From Hailakandi to Kachhar.
Sure. Family.
Is he appearing in your DV case? Yes. Is he appearing in the domestic violence case? No.
Yes.
Yes or no?
Yes.
He's appearing. Mr. However, it is submitted that the petitioner, the respondent is appearing in the proceedings of CR within bracket DV bracket close, sorry, DV Act bracket close, case number 136 of 2025, which is pending for disposal before the Court of Learned Chief Judicial Magistrate, Kachhar at Silchar. Next paragraph. Before comma, taking into consideration the principal remark of refusal by the respondent to accept notice, comma, the notice is deemed to be duly served on the respondent. Next paragraph. However, for principal justice, comma, the court is inclined to direct the petitioner to produce a certified copy of the order dated 30/3/2026, passed in this transfer petition before the Court of Learned District Judge, Hailakandi, in the proceedings of TS within bracket matrimonial number 44 of 2025. Along with the petition, to bring the said order to the notice of the said learned court. This was also constitute a due notice to the respondent of the present proceedings. First off, the learned counsel for the petitioners have obtained instructions as to the petition number for which the certified copy of this order or the order dated 30/3/2026 was produced before the learned trial court. Next paragraph. List again for further consideration on 17/6/2026. Produce a certified copy and then tell us how you have filed it, then we'll consider.
Obliged lordship.
Okay, interim order passed today stands extended to the next date of this time.
Item 38.
Okay, further consideration. Interim order. Item 38.
My plea, Lordship. Lordship, 2 days time may begin, Lordship, for take steps.
you'll have to tell us why this application should not be dismissed.
Lordship,
You'll have to tell us why this application should not be dismissed. What
I'm-
happened in the trial court? What was the suit before the trial court?
Annexure 1, Lordship, page.
No, what is that suit? Before the trial court, what was the suit?
Lordship, I'm not aware, Lordship. My senior is preparing this case, Lordship.
So,
I'm just taking
You-
the
you-
time, Lordship, to take his steps.
no. The adjournment is the most difficult thing in this bench. Even for steps. You say that the plaintiff is at annexure 1. You can just open it and tell us what is the suit about. So what is the suit about?
Kindly sign time, maybe the Lordship. I'm not aware, Lordship, in this case. 2 days time, maybe the Lordship, for take his steps.
Okay. The lawyer counsel for the, your name, what is your name?
H. Islam, Lordship. H. Islam.
H. Islam.
Islam.
Mr. H. Islam, learned counsel appearing on behalf of Mr. B. Sundar, learned counsel for the petitioner, submits that he has no instructions in the matter. He is wait for 2 days time to take steps for service of notice on the respondent. Next para. It appears that the that the respondent as plaintiff had filed TS number 43 of 2018 for eviction of the for the petitioner, which was decreed, and the appellant had and the petitioner had unsuccessfully challenged the decree of the trial court before the learned first appellate court. Against the decree of eviction passed against the petitioner for eviction as a tenant from the tenanted premises and for area recovery of area rent. Next para. The present application to challenge the first appellate order of rejection of appeal, dismissal of appeal, and the trial court order for eviction has been assailed by filing this application under Article 227 of the Constitution of India. So accordingly, on the next date of listing, the Learned Counsel for the petitioner shall address as to the maintainability of this application. Next para, list on. To the time, make it 36/26. Thirty-nine.
Lordship.
Item 39.
Yes.
This is service of state lawsuit. Then is the law. Letter made fixed for admission from another day lawsuit. Today, the senior is not available.
Yes, look.
When do you want?
After 1 week, Lordship.
After a week, okay. Please, Arya, for the learned counsel for the appellant, and Mr. R.B. Futan, the senior counsel, assisted by Ms. D.
T.
T. T.
T. Delmari.
T. Devmani, learned counsel for the respondent. Present, next para, as the case is ready as regards service. The prayer made by learned counsel for the petitioner, yes, Tom. 8/6/2026,
Public.
for in the admission column.
Correct.
Item 40,
The lordship. So here, respondent number 2, my friend is preparing for other respondents who has already expired, my lord. So, my lord, I have to file substitute petition sometime.
it was expired, okay. You are for 1 and 1, 3, 4, 5 and 6. 1, 3, 4, 5 and 6. Okay. Mr. M.R. Khandekar, learned counsel for the petitioners, has submitted that respondent number 2 has expired, and he prays for some time to take appropriate steps. Next, Mr. B.K. Borwa, learned counsel for respondent numbers 1, 3, 4, 5 and 6 is present. This after 2 weeks. In the meantime, the petitioner shall take appropriate steps.
41 for orders.
May I please? Madam, in this case, on last occasion, 16/5/2025 matter, the learned counsel for the opposite parties had informed this court that several respondents were already expired. Oh. So I was directed to file substitution petition. And I have filed the substitution petition accordingly, one condemnation petition also. So regarding condemnation petition, my lord, may I create it, let there be a notice to the opposite parties, my lord. Okay. Several respondents died. Okay. So notice that.
I am for respondent number, my lord, 1.1 and 4, my lord.
Roman 1 and 1 4.
Roman 1.1 and 4, my lord.
Roman 1.1
Yes, my lord.
and Roman 1.4.
Not my lord, only 4, my lord.
That's a 1 4. Okay.
Yes.
That's 1 4. 1 1 and 1 4. Okay. Last order on 16/5, my lord. Dr. P.K. Goswami, learned counsel for the applicants, has submitted that paragraph 11, page 19. my lord. So, please look at your paragraph 11.
Yes, madam.
Kindly examine, you see what has happened here. This second appeal was filed on 30/7/2024. Please note that dates will be relevant. So you can just take down the note dates, it will be relevant. Just take it down. This connected second appeal was filed on 30/7/2024. Now, out of this, the deceased respondents, respondent number 9 died on 5/4/24. Katu Payang died 27/4/24. The date of Nadi Payang is not available. Respondent number 12 died on 18/8/24. Therefore, only one respondent has died during the pendency of the appeal.
Yes, madam.
So only for that, perhaps application for substitution would be maintainable. For 9, 10, and 11, I think there cannot be a substitution because they have died before the appeal was preferred.
Not informed.
No, but still you take, that's why we are saying that these are the dates, you please take a call. You have to take a call whether you will want to file it here or under order 1 Rule 10(2), please take a call. But I'll issue notice. Notwithstanding that, I'll issue notice, otherwise there will be more delay. Also have Mr. M. Hussain, 11 council opinion for respondent numbers 1.1 and 4. That's correct. Is the filing of this application under Section 5 of the Limitation Act, the applicants who are the appellants in the connected RSA 25 of public 2025 paid for considering the delay of 2461 days in filing
Substitution petition as well as setting aside abatement.
in filing the connected applications for setting aside abatement. No, Mr. No, Dr. Goswami, you'll have to address us because out of the deceased respondents, this respondent 20, Urvashi Payang, died on 10/6/2020.
Yes, madam.
And 23 died on 12/11/18. That is before the.
So I had to file a case against.
No,
dead
but
person.
but those people died during the pendency of title appeal 12 of 2006. So they cannot be substituted here in appeal. So perhaps your only remedy would be under against those all persons. If either under order 1 rule 10 2 or some other provision which we'll have it next week. In the meantime, you come prepared. So this, in this application, we can't condone the delay of, for the death of two respondents who have died during the pendency of the earlier first appeal. 10/6/2020 and 2011-18. That we may not have power to condone. Let it be fixed on next week. As it is noted that out of the respondents, several of the respondents have expired. The respective date of the respective date of deaths are as follows. You take it from page 19 to (1920). Respondent number is 9. Just like the respondent number 9 died on 4/5/2024. So only this this type of statement. Number 9, 10, 11, 12. The next page you will find 19, 20, 23, and 28. This comma. At least this comma, the date of death of respondent number 11 is not available, and insofar as the respondent numbers 20 and 23 are concerned, comma, they had died during the pendency of title appeal. Number 12 or 2020 of 2006, which were disposed of by judgment and decree dated 23/2024. Okay, 28 also, 28 died. Just accordingly, and expire the Eleventh Council for the applicants are will grant us some time to address the court as to the proper on the manageability of the application in the present form. Just on next list on. Dr. Goswami, when it will be convenient to you? Can it have 8? Yes. Okay, 8. 6:20 for that. Hello, instead of 8, my lord, it may become 9 or 10. 10? Dr. Goswami, go for it. I think it will be, this application may not be maintainable for this. It ought to be order 1 rule 10. At least some of them will be substituted. Just find out. Yes. Item 32. May you give me copy?
My lord, I was surprised that he has not received a copy.
No, my lord, they are not servicing at all.
Regarding the IA, my lord.
Give me copies.
I'll give him.
Don't express surprise. Give me. He's asking for a copy.
My lord, I'll provide the copy.
He would not ask for copies if he has got it. correct?
No, 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 no.
Yes, item 42.
Please, Your Lordship.
Yes,
Lordship, there's been a IL Lordship, 1127 Lordship, for
Yes.
substitution Lordship. Here Lordship, so sole appellant is that Lordship, that's why we have filed this IL Lordship, for substitution of the legal
all
debt.
appellant had died.
Yes,
What is the date of death?
5/1/2026 Lordship.
5/1/26.
26 Lordship. This the application has been filed on 2/4/2026 Lordship.
Okay,
This is within time Lordship.
you are the appellant.
Yes, Lordship.
Okay. Heard Mr.
M. Das.
M. Das, learned counsel for the applicant. So you are appealing for?
Respondent one is the creditor.
Okay.
M Nath.
And Miss N.
M Nath.
M. Nath, learned counsel appearing for the respondents. Next, we are around this application
Yes, yes.
by by filing this application under Order 22, Rule 3, read with Section 151 CPC, the applicants are praying for substitution of their names as the legal representatives of the sole appellant, Srimati Leela Bala Thakuria, who had died on 5/1/2026. Next paragraph. You've seen that the present application has been filed on 2/4/2026. So accordingly, it is within the period of limitation prescribed for substitution. What will be limitation act will be 120 or 121? Substitution. Which is 90 days under Article 120 of the Schedule to the Limitation Act, 1963. Accordingly, as the application is within time, the application for substitution of the sole appellant is allowed. The sole appellant by the applicants is allowed. So the applicant numbers 1. No, the supplement number 1 to 10
1 to 10.
is allowed. So the application stands disposed of. In the main case, you say that in view of the Hertz transfer, in view of the order passed in IS 1127 of 2026, allowing substitution, the appellant is permitted to submit a fresh cost title to the AOJ second appellate section, appeal section, and to the AOJ second appeal section for incorporation in the memo appeal and for consequential amendment to the CS system, CS data. First one. And thereafter matter be immediately listed for passing appropriate orders.
Obviously.
43.
But I am appearing on behalf of Mr. A. Rahman Malak. I am appearing on behalf of Mr. A. Rahman Malak.
Yes.
I'm personally here to leave the court matter due to some urgency.
Okay. Okay.
I was filed for substitution of respondent number 1 matter on that date matter. The respondent number 1.
Okay. What is the date of death?
Well, that date of death could not collect matter. Stated at paragraph 2 matter, 2 and 3 matter.
No, but your both statements are contradictory. In paragraph 2, it is stated that on 16/3, applicant has come to know that about 2 months back, the respondent woman has died.
Right. But he could not collect.
And then it is within time, therefore the time will run only from the date of death. How will we calculate the date of death? Because both of you reside on in the same village.
Right.
If you are residing in the same village, okay, we are issuing notice only then.
Right.
Otherwise, we would have allowed it.
Right.
Okay. This as Hotline Counsel who appears on behalf of, who appears on instructions of Mr. A. Rahman and counsel for the appellant, for applicant. Next para. By filing this application under Order 22 Rule 4 of the CBC, the applicant who is the appellant in the connected appeal has prayed for substitution of the legal representative of the respondent number 1. Next, it is submitted that this application was filed on 30/3/2026, and according to the applicants, they do not have they could not collect the date of death, but on 16/3/2026, they came to know that the respondent number 1 had died about 2 months back. Next, be that as it may, issue notice on the proposed respondent numbers 1A to 1D by speed post to DD, which is made returnable on so and so. Applicant shall take steps within 2 days for service of notice on the substituted on the proposed respondent numbers 1A to 1D by speed post with AD.
Right.
As per the law, passport applicant is permitted to collect the effective visit number and to submit postal track report prior to the next date of listing. Next part is on
24 to that.
Right.
item 44.
44.
Please, your lordship. It is revision I number 1676. This for subdivision of this is respondent number 1A, lordship. Within the 1A is died, lordship. And he is died on it 5/12/2025. And we have filed this IA, lordship, on 27/2/2026. It is on time, lordship.
Who has died?
1A, lordship. This is Mr.
Respondent.
Yes, lordship. Respondent 1A, Dhiraj Deta.
Yes, any objection or you can allow it?
Yes, Your Worship, you can.
Okay. Heard Mr. M. Das and counsel for the applicants. And Ms.
M. Nath.
M. Nathan, counsel appearing for the respondents. Respondents, next one. This, predicted in this application that the respondent number 1 had died on 5/12/2025, and this, so one E, one within bracket E had died on 5/12/2025, and this application for substitution was filed on 27/2/2026 for substitution of the legal representative of the deceased respondent number 1A, which has been filed under order 22 rule 4 read with section 151 of the CPC. Next paragraph. It is seen that although the application was filed on 27/2/2026, but as there was a defect owing to the fact that all the applicants had not signed the Vakalatnama, the said defect was cured only on 25/2026, and the matter has been listed. Next paragraph. As the application was filed on 27/2/2026, and the defect is not regarding the application, but for the supporting affidavit, supporting a Vakalatnama, the court is of the constitutional opinion that the application was filed within 90 days time as allowable under Article 120 of the Schedule to Immigration Act. Accordingly, the period for substitution is of deceased respondent number 1A is allowed. One A by proposed respondent numbers 1A1 Roman 1 page 6 of 1A Roman small Roman 1 CO2 no sorry and 1A2 is allowed. Next time the application stands disposed of, and in the main case main appeal you say but so in view of the order passed today in IS Civil 1676 of 2026, commonly allowing substitution of respondent was respondent number 1A, learned counsel for the appellant shall file as amended cause title and hand it over to the AOJ second appeal section for being incorporated in the memo of appeal and for updating the CIS data. And thereafter the matter will be distributed again the court at the earliest. Okay.
No.
Supplementary item 45 or orders.
May I please, Your Lordship? On an earlier occasion, Your Lordship asked me to produce some photograph of the Malat Scotland one.
Show it to him also. Just show it to him first.
Yes. Geotech one.
Yes.
old, my lord, Assam type, my lord, residential, my lord, house is standing on the sweetland. And presently, appellant side is reciting, my lord, thereon. Appeal was admitted on, my lord, 9/1/2023, my lord.
Okay. Let's take the execution then. Till the appeal is heard. Heard Mr. A.M. Bogwell and counsel for the applicant. And also heard Mr. I. Ahmed, learned counsel appearing for the respondent. Respondent. He's appellant. Appellant, not us. Next, for the by this interlocutory application file and order 41 rule 5 read with section 151 CPC, comma, the applicant who is the appellant in the connected RSA 75 of 2019 has paid for stay of the execution of the decree dated 13/6/2012 passed in case 872 of 2006 by the Court of Learned Municip number 1, Kampo Metro, Gauhati, as affirmed by the First Appellate Court, right? First Appellate Judgment and Decree dated 31/2018, passed in TA 91 of 2012, passed by the Learned Civil Judge number 3, Kampo Metro, Gauhati, in TA 91 of 2012. Pursuant to order dated 27/5/2026, the learned counsel for the petitioner has produced 3 photographs of the suit land with geotag locations, which is taken on 30/5/2026. To show the current status of the suit land. The same is made a part of the record. Next para, there's the connected appeal has already been admitted for hearing by order dated 9/1/2023, comma, the court is inclined to stay the execution of the That same judgment and so and so, passed by so and so, as affirmed by the appellate court and so and so. Most of these applications stands disposed of. It will have already go. Do that. In appeal, you say, heard so and so. As the appeal is ready, cigar service and the record of the travel is received. And as the matter pertains to the year 2019, is the matter for hearing. 18/6/2026.
It might be 6. Has it can it be after vacation, Lordship?
After vacation. Okay, then
In the month of July, Lordship. Lordship, we have, just now we have received the brief, Lordship, and till now we have not completely received the copy. So my humble prayer, Lordship.
Okay, it's okay.
Immediately after vacation.
Immediately after vacation, Lordship.
28/7/2026. Okay.
Obliged, Lordship. Deeply obliged.
Diploma.
Item 46 for orders.
Lordship, Your Lordship may kindly take note of the order dated 27/5 matter.
Yes. Yes.
Malot 27/5 order, Malot, that Lordship, the appellant was supposed to take steps upon the restaurant number 2 and 3, Malot. They already suffered expired, Malot.
Oh,
Yes. So perhaps they
Yes.
have not, Malot.
Lordship, in the meantime, I would like to raise the court. There has been an SLP that is pending in view of the IA 2357 of 2025. Already a mediation.
So the number was something.
Number was something number 2649.
no, this has got nothing to do. His submission is that the respondent number two had died in 2009. And respondent number 3 has died in 2020.
And the appeal is evicted in the meantime, Malot, because in the first order, Malot, I pointed out that while admitting this appeal, Malot, on 8/8/2025, and till that they have not taken steps in this regard, Malot.
So, Lordship, Mr. Soma of the standing counsel ASTC will be able to apprise the
Hmm?
court. Mr. Soma is the leading counsel in this case, Your Lordship. He'll be able to apprise the court regarding the same. But due to his being unwell, he's unable to appear today.
Worship may kindly grant us a week's time, he'll be applied, so he'll apply the court, I think,
Okay, your name?
Worship Y.N. Mahanta.
Hmm?
Y.N. Mahanta.
Mr. Y.M. Monta, and Council enters appeals on behalf of Mr. A. Samuel and Mr. Manikas for the appellant. Next, Mr. B.K. Das, Learned Counsel, appearing for respondent numbers 1, 4, and 5.
Yes.
Has reiterated the statement, his submissions made on 8/8/2025 and 27/5/2026 that the respondent number 2 had died in the year 2009, and respondent number 3 has died in the year 2020. So accordingly, it is submitted that
No steps has
as
been taken.
no steps has been taken since 8/8/2025 on the present appeal is awaited. Next paragraph, Learned Counsel appearing on behalf of the Learned Attorney Counsel for the appellant prays for some time so that the Standing Counsel for the appellant can address the court. So matter stands adjourned today. Most again on 5/6/2026.
Much obliged, Your Lordship.
Forty-seven.
Wait, please, Your Lordship. This IA is for promotional delay of 3756 is in filing application for admission of appeal. That's come up for the first time today.
756, almost 10 years delay.
Yes, sir.
You have to give a very good explanation even for issuance of notice.
It is in paragraph 4.
No, that's okay, but what is the ground?
Actually, dismissal was not within our knowledge, but when later in the year 2026, when the party made the advocate, then it came to a notice that the case was dismissed. And in the meantime, the advocates were associated with deemed the all were certain independent practice. And Mr. N. Chakraborty was local council of Dorong. He is also started practicing there. Therefore, the matter remained overlooked. Otherwise, it was very in the policy, it was regularly being checked whether the cases are listed.
Something appears to be wrong. You see, come to the, you have a copy of the memo appeal?
Yes, sir.
Come to the original suit. Who is the defendant number 3 according to you in this suit? Copy of plaintiff is where? Who is the plaintiff? Defendant number 3? In the decree, in the page 17, that is the decree. In decree, defendant number 3 is not there.
The plaintiff is Mohammed Noor Hussain.
Hmm?
The plaintiff is Mohammed Noor Hussain.
Mohammed Nurul Hussain.
Yes.
Now, defendant number 3 is the respondent number 3 in the present appeal. Who is the respondent number 3 in the present appeal? Haraj Ali.
Faraz Ali. Because he might be the son of Abul Hussain.
No, not that. Haraj Ali is the plaintiff.
Yes.
So
And
plaintiff number 3 has died.
serial number 15, Mohammed Noor Hussain.
No, I am not on that. I am just asking who is the defendant number 3?
Defendant number 3 is Mohammed Noor Hussain.
Noor Hussain.
Yes.
So, but in this judgment in decree that Noor Hussain is not there. And who is in this memo appeal, who is the respondent number 3? Is Haraj Ali.
Faraz Ali.
Now, this Haraj Ali has died in the meantime. That was in the pendency of the appeal, and there's a judicial order saying that the appeal is abated. So, if the decree, if this is abated, then what would happen to the notice will not go to respondent number 3.
Yes.
And if that is abated, how will you be entitled to any relief in this? You just find out and address us, we'll take it up on Friday.
Yes, sir.
The Mr. R. Sharma and counsel for the applicants. Next para. It appears from the record of RSA 49 of 2005 that as per order dated 15/11/2012, 10, the learned counsel for the appellant had submitted that the respondent number 3 had died long back without leaving behind any legal representatives. And therefore, As per order dated 15/10/2010, the court has recorded that the appeal stands abated in respect of respondent number 3, and thus, the question of maintainability of the appeal in absence of respondent number 3 was to be considered at the time of hearing. Mr. However, the appeal was dismissed for non-prosecution by order dated 12/10/2015. So therefore, the issue regarding abatement of the appeal on account of death of respondent number 3 is having already been framed, the learned counsel for the applicants shall address the court on on that aspect of the matter. Next para list on Friday. Yes, list on 5, 6, 6. Production to video.
For production under motion column CRP IO 203/2026 Subhas Sharma and another versus Muhammad Mustaquddin Ahmed.
Lordship, in a very peculiar facts and circumstances, we have to approach this honorable court, Lordship. What happened? The present petitioners are the owner of two contiguous plot of land, a roadside land, 3.5 leases and 5 leases respectively, covered by tag number 714 of Patta number 442 of Village Borsajai, which they had purchased from the recorded owner by two registered sale deed in the year 2018. Prior to purchasing the said land, they were running their business over the said land as a tenant under their vendor since 2014 till 2018. So therefore, since 2014 till today, they are running their business over the said land. The petitioner number is running his tea stall business, and the petitioner number 2 show his as in running a pharmacy. In the last part of April, one person happens to be the civil nazir went to the said land, stating that against and asked the petitioners to vacate the land, stating that a decree has been passed in a suit filed by the respondent number 1 herein against the respondent number 2 herein, of claim for declaration of right title interest, recovery of possession. So after coming to know that, the petitioner immediately applied for the certified copies of all the documents. So after getting some of the documents, the petitioners found that the respondent number 1 hearing filed a suit, simple suit, stating that his grandfather was the owner of a big plot of land under different deed. And after the death of the grandfather, his father inherited the said land, and then he inherited the said land. And defendant number 2, who is the judgment that is respondent number 2 hearing, he was allowed to remain as a caretaker of the said land, and he started their scrap shop over the said land. So in the year 2025, when the respondent number 2 was asked to vacate the land, so he has refused to do so. Therefore, he has filed a suit for declaration of his right title interest, recovery of possession, and permanent injunction. In the first, the suit was proceeded ex parte against the defendant number 2 in that suit. Then, on the next day, defendant number 2 appeared and filed an application for stay vacating. So before the stay vacating was allowed, the plaintiff and the defendant number two file a suit, this respondent to file a application stating that they have settled the matter outside the court and the defendant agrees to vacate the land. So therefore, a compromise decree may be passed. On the basis of that, a compromise decree was passed by the learned civil judge number two, that is at page 73 lawsuit. So after this compromise decree was passed, civil nazir then initiated the execution proceeding, wherein the civil nazir present, and after going through the civil nazir found that the different person is sitting, there is no scap saw. The one tea stall and one he submitted a report before the executing court stating that the decree cannot be executed in absence of police officials and the revenue officials. So accordingly, Lordship, kindly page 77. So the decree holder, that is the respondent number one hearing, was directed to deposit the cost before the executing court.
Page number?
Page number 77 and extra 15. Lordship, go ahead.
Yes.
Decree holder is represented. Civil Nazir has submitted report that the writ could not be executed. Assistance from the Mandal, Kanangu and police help are required. Therefore, decree holder is directed to take step accordingly. Fixed 2154 Salan for police report. Cost of Nazir's ransom. So on as the petitioner does not get the entire copy, so therefore on 21/5 submitted an application before the executing court that they want to file an appropriate application for which some time is required because copies are not getting. So some time may be given to them. That application is page 99 and the order on that petition that order was at page 84 lawsuit. Annexure 18 lawsuit got it. The decree holder is represented. Decree holder has submitted Salan of police cost. In petition number so filed by the petitioner, third party paid for adjournment for filing appropriate application. Hard and prayer is allowed. In the meantime, on the one hand, allowed the prayer for submitted appropriate application. On the other hand, reissue the writ. So after that, getting all the copies, the petitioner filed a separate suit because he came to know that the decree has been obtained by means of fraud, misrepresentation, concealing the material facts, and in collusion between the plaintiff, his attorney holder, and the defendant. So therefore, file a separate suit challenging the decree and their right title of interest over their respectively. That is page 99 is the plaint of the suit filed by the petitioner. So prayer portion is that logic decree, sought for the decree in that suit is page 108. Logic. Declaration of right title interest of the plaintiff over the civil AB land, their purchased land. Declaration that the judgment and decree dated 14/6/2025 passed by the Honorable Civil Judge Kamru matter so-and-so title suit number so-and-so is obtained by the defendant number one in collusion with the defendant number 2 and 3 by means of fraud, and as such the same is not binding upon the plaintiffs. Declaration that the defendant number one having no right title interest and possession over the civil AB land, and as such the judgment and decree dated passed in so-and-so shall not have any effect over and in respect of the civil AB and land. Confirmation of possession, next permanent injunction. So along with the suit, an injunction application was also filed, and the learned civil judge number 2 after 3 by order dated 27/9/2026, that is at page 126 lordship, in the operative portion at lordship at page 140 lordship, paragraph number 12. Hence, after taking into consideration the entire matter and scenario, an ad interim injunction order is passed restraining the opposite parties. Opposite parties are the decree holder and the judgment debtor of the suit. Their men, agents, employees, assignees, service, and or any other person claiming through them from disturbing the peaceful possession of the petitioner over the civil A and B land, and from disposing the petitioner from the civil A and B land till next step. So, after getting this injunction order, petitioner file an application before the executing court intimating the aforesaid fact and hereby prayed for recalling of the writ issued for delivery of possession and to keep the execution proceeding in abeyance till adjudication of their claim. So that application is prayer at Lordship at page 145. Lordship.
Yes.
In the premises, therefore, it is therefore prayed that Your Honor will graciously be pleased to admit this petition and further be pleased to recall the writ issued for execution of the decree and also to keep the instant execution proceeding in abeyance till disposal of the title suit number so and so pending before the so and so and are pleased to pass such order. So by the impugn order, that is the next page, Lordship, page 146, 29/5/2026, the learned executing court rejected that application, stating that no appropriate application has been filed.
Correct. You also had same view.
No, Lordship, here suit land is different and the decretal land is different. Decretal land is under DAG number 715. It is our specific case that in between our land and the road, there is no land under 715. Whatever land was, that was merged with the road long back. Since 2014 till date, we are running our businesses over the said land. So therefore, that declaration we have sought again that there is a fraud and collision in between the decree holder and the judgment debtor. So therefore, we have filed a separate suit.
You see, if there's a requirement of stay, if it is the same property, then it would be, I think, order 21 rule
Yes,
29.
Yes, order 21 rule 97.
It will be 29. If I'm not wrong.
That is a stay of execution pending suit between decree holder and judgment debtor in between the same party. Here we are not parties to the suit. And there is a collision. They knowing fully well that we are running our business over the suit land. They have not made us party to the suit.
Where is the decree passed in the earlier suit 31 of 25?
Yes,
the decree?
that is compromise decree. That is at page 73, Lordship. And the petition on the basis of which the decree was passed, that is at page 69, Lordship.
So that decree will be executed in 715.
Yes.
You say that you are not occupying 715.
Not, there is no land under 715
Then what
because
is
they
the-
are showing our land to be
No,
715.
and we understand.
Yes.
But what happens if they go and don't find 715?
Yes,
How are you apprehending that they will execute it in 714?
because there is no land. There is on the roadside in our cell deed, Lordship. Kindly come to our cell deed, Lordship. And they asked to vacate, Nazir asked to vacate the land. Lordship, come to page 33. It is the petitioner's cell deed of 2018. Lordship got it.
Page number?
33, Lordship. South Vishnu Rabha Path, that is called also Ghoramara Road. Then in the second petitioner's cell deed,
Where is the trace map of the area?
trace map, what happened in the trace map, though there is no land in the DAG number 715, but in the trace map, due to non-correction by the revenue authority, a stripe of land has been shown.
Then it's a question of fact finding.
Therefore, we have filed a case with our specific case. There is no land under DAG number 715.
No. It's very hard to believe. The problem is that the interpretation clause under the Transfer Property Act
Yes.
says about notice. Who will have notice of fact? If it is in your land, there is a boundary
Yes.
which is being shown in the revenue map.
Yes.
that will be, this is when you have executed the sale deed. You
Yes.
must be aware of that.
Because prior, the shop room are long back constructed by my vendor. Earlier, we
No,
were
no,
under
then,
tenant.
You see, that's immaterial.
Yes,
The fact is that where is your land situated? Your land situated is at page 33,
yes,
north, south, east, west.
yes. South is Vishnu Ravapur. That is the road.
Yes. So here you see, but for the abstinence,
Yes.
had you seen the land record, you would have known that in your opposite.
Because we have obtained permission.
No,
Because
we don't know whether the land of the government has taken over the private land to build the road. We don't know
yes,
that road.
yes,
If it is a road, it would
Yes.
be always a Sarkari land,
yes,
but it is not.
yes.
There is a, in the revenue map,
That,
there is
that,
a locality.
that issue has to be regarding fraud, Lordship. I have exhibited I have annexed the Jamabandi of the DAG number 715. As per the Jamabandi, there are several pattadars, not his grandfather. In fact, his relative of the grandfathers are the pattadars, 9 to 10 pattadars of their grandfather. So therefore, entire narration made in the plain that his grandfather was the owner, after that his father got, then he got. So all are false because they are neither the pattadars has been made party. Assuming for a moment that we are not the owner of 715 and we are possessing 715, then also a notice has to be asked that we are illegally possessing. In the suit, we are not made parties. Notice page 85, annexure 19, Lordship. That is the Jamabandi of their as per his plain version, his grandfather is Mujibuddin Ahmed. First one. He is the son of Didaruddin. Next one, Abdul Haq. He is also Didaruddin. Next, Kutubuddin, minor represented mother Gulbahar. Then Gulbahar, wife of Didaruddin. Then Nuran Nahar, Mir Qasim, Nazrul Nasa, Afzal Hussain, all are his relatives. So his grandfather is the not sole pattadar of this land. And his name, the father of the plaintiff's father's name is not mutated. And entire narration that the defendant is running a scrap business over the land is totally false. It is a collusive suit. So therefore, on the first day, suit was proceeded ex parte. Then it's before recalling that ex parte order, then they filed the compromise petition and agreed to vacate the land. If he agreed to vacate the land, why execution is required?
The original pattadar would be Didaruddin Ahmed.
Yes,
So it is his grandfather.
yes,
You see, you are producing before us Jamabandi,
yes,
but this is the e-copy of the Jamabandi.
yes, sir.
You see, if
I am saying that these Didaruddins have many children. One of them is Mujibuddin Ahmed. He claiming the land by virtue of the legal heir of Mujibuddin. But Mujibuddin is not only the pattadar, other pattadars are there.
you are not claiming to any other pattadar.
Yes, yes,
So therefore, what is their relationship is not the inquiry.
yes, yes. So
But if
there,
you,
yes,
but if you, you see in Gauhati, there will be very few civil lawyers who have learned anything in civil side without knowing this family. If there is any lawyer of any credit, of any of any status,
yes, sir.
they would not have become a good lawyer without knowing this family.
And so interestingly, later on we came to know that 3 suits has been filed with the same replica of
Not only this family will have not less than 100 suits in the Gauhati.
yes,
That's why I've told you that
Yes.
nobody would have become a good lawyer without dealing with this family. And therefore all this land belongs to Nizaruddin Ahmed.
Yes.
He had no other, there was no no other patazar in his land ever.
Yes. But in my case, already an injunction has been granted in our favor. So therefore, we prayed before the executing court, since an injunction competent civil court
There is
has.
an injunction, but not against the court. There will be no stay of the decree of the court.
Yes, sir.
You can enforce the injunction that he cannot execute.
Yes, that cannot, therefore we have not.
Therefore, you will only be able to press before the court
Yes,
that there is an injunction that he would not be able to do it.
so
And
we
that-
have, Lordship, we have filed a separate suit only because we have sought several prayers which we cannot seek.
No, but can there be an injunction against the court?
Yes.
No, there cannot be any injunction against the court.
No.
So you have not got any order restraining the execution to proceed.
That order we have not sought for the other.
Then
So only sought for the not to dispose and not to disturb our peaceful possession. So if the one civil court has granted us injunction, and if the other civil court send the bailiff to deliver the property, then it will be
but there is
violation
an
of the
exception.
injunction.
There's no, because you see, they are not injuncting the court.
Not injunctive court,
The-
but
you can still have the remedy against the person who is executing.
yes,
Can there be an injunction against the court?
no.
Then
So admittedly, Lordship, we have filed a suit. So two applications we cannot file. In order 21, rule 97 now we cannot file. Because in our suit is a comprehensive suit. We have challenged everything. And the finding recorded in the impugn order that on 29/5 also we have sought for time for appropriate application is not correct. In our application, we stated all the facts that after getting the copy, we have filed a separate suit and got the injunction.
Mr. Dekha, please tell us,
Yes, sir.
how do you want us to enforce the orders? You see, if there is no land, you say that the land was usurped by the road.
Yes,
This is a finding of fact which the trial court will, the executing court will have to do.
yes.
But you are not filing an objection as to the executability as the non-availability of the land. There is nothing to show
No,
that this
because
land
we
is
have,
not available.
no, because we have not filed before the executing court, because our land is under DAG number different. And we are possessing since 2014 continuously by running shop. So therefore, we have filed a suit and challenging the decree itself. Since the very decree is under challenge, so therefore, so my humble submission,
Where is the copy of your plate?
copy our friend also. That is at page 99 also. Another aspect, Lordship, as per 47, section 47 of the CPC, Lordship, executing could decide the issues in between the parties to the suit.
And where is the decree you have shown us?
Decree at page, Lordship, judgment and decree at page 73, Lordship.
What is the next date of the proceedings before the executing court?
On 6/6, Lordship, for report on the exhibition.
Six.
As per our information, tomorrow, civil Nazir will move for exhibition, Lordship.
Mr. S. Dekar, and counsel for the petitioners. Next paragraph. Receiving the order dated 29/5/2026, passed by page 146, passed by so and so and so and so. The present application has been filed under Article 226 of the Constitution of India, by 7 of the Constitution of India. It is the case of the petitioners that the compromise decree dated 14/6/2025, passed by the learned civil judge within bracket senior division, bracket goes number 2, Kamrup Metro, Gauhati, in TS number 31 of 2025, is fraudulent, and accordingly the petitioners were the third parties to the set TS 31 of 2025, have filed a separate suit which was registered as TS number 340 of 2026, which is pending for disposal before the court of learned civil judge within bracket senior division, bracket was number 3, Kamrup Metro, Gauhati. Full stop. The two plot of land in which, in respect of which decree was passed in TS 30, it is 30 or 31?
31, Lordship.
31 of 2025 are as being Schedule A and Schedule B are as follows. Page 75. Full stop. Next para, the two plot of land for which title suit number 340 of 2026 was filed. Two parts of that, Schedule A and Schedule B for which the suit was filed is are as follows. Page 110. And accordingly, it is submitted that the case of the petitioners is that there is no land of the respondent numbers 1 and 2.
1.
Number 1.
Yeah.
Within the land described in schedule to the plaint of TS number 340 of 2026, and accordingly by the following decree passed in TS 31 of 2025, an attempt will be made to take over to execute this said decree in the land of the petitioners. So it is submitted that the learned civil judge within bracket senior division bracket close number 3, Kamrup Metro, Guwahati, had granted the interim injunction under order 39 rules 1 and 2 read with section 151 CPC on 27/5/2026, restraining the respondent numbers 1 and 2 from executing the decree passed in TS 31 of
Not the plaintiff, not to disturb us.
not to disturb possession of the
And this
petitioners over the Schedule A and Schedule B land, which is described in a plaint of TS 340 of 2026.
and not to dispose us. And not to dispose us.
And not to disposes them.
Dispose.
Okay, not to disposes them. Okay. Next paragraph. Issue notice returnable. Next paragraph, it is submitted that the said order was presented before the learned civil judge within bracket senior division brackets close number 2, Kamrup Metro, Gauhati, in TX number 42 of 2025 into page 146. Just of how the said learned court by order dated 29/5/2026 rejected the said application. Just accordingly, this present application has been filed. Next paragraph. Issue notice returnable on so and so. Because the petitioner shall take steps within 2 days for service of notice on the respondents by speed post in AD, as well as the usual process to be served through the jurisdictional civil court. Next paragraph. When the court is disinclined to stay the execution, but at the same time the civil nazir attached to the debited for the execution of the decree dated 14/6/2025 passed in TS number 31 of 2025 by the Court of Learned Civil Judge within bracket senior division bracket close number 2, Kamrup Metro, Guwahati. Is directed to take into consideration the order dated 27/5/2026 passed by the learned civil judge within bracket senior division bracket close number 3, Kamrup Metro, Guwahati, in NISJ case number 623 of 2026. Just to prevent the execution on any part of the land which is covered by Schedule A and Schedule B of TS number 340 of 2026. Next paragraph, the petitioner shall produce a copy of this order before the civil judge, senior division number 2, Kamrup Metro, Guwahati, as well as to the Nazir attached to the Nazir under the District Judiciary at Kamrup Metro, Guwahati, to stop. It is made clear that if the decretal land is outside the suit land described in Schedule A and Schedule B of the TS 340 of the 2026, this order shall not be a bar for the execution of the decree, strictly in terms of the decree dated 14/6/2025, passed by the learned civil judge, senior division number 2, Kanpur Metro, Gauhati, in TS 31 of 2025. So that would be respected, but if the execution is outside the scheduled land, they will do it. So if you are encroaching on any part of that land, then you have to give way.
For that purpose, first, board has
Okay,
to
Mr.
ascertain.
Saiwala, your matters will be taken up tomorrow because I have 2 meetings to attend.
No problem.
Is that tomorrow? No. Which school you? We'll give a date. Acha, it will be said tomorrow. Huh?
Great.
Positive time, I could not be taken. That's also.